Yes.
Your Lordship, there is a grave urgency regarding an autistic girl child who is 8 years old. Autistic, she is severely autistic child.
What do you want?
Lordship, her mother has taken her away from USA and come down to Kolkata. And 5th of October, there is a visa stamping in consulate in Hyderabad. There's urgency, a lot of urgency. Visa stamping for the girl child on 5th of October in consulate Hyderabad, US consulate. There's urgency, Your Lordship. We are filing an application, writ application for that.
Habeas corpus.
Yes, Your Lordship.
So she wants to go back to USA.
The father wants to take her back because she's severely affected child, autistic child. Her therapies were continuing there in US in special school.
Child is with the mother now.
With the mother, but she came from USA without telling anyone. And when he landed here on 29th of this month.
For the father.
Yes, Your Lordship.
Who is your mother is a party. Have you served the mother?
We are going to serve, Your Lordship. Just today we are filing it, Your Lordship. If it can be listed tomorrow, Your Lordship, we're going to serve and do everything, Your Lordship. Kindly, Your Lordship. It's very urgent. The girl cannot speak for herself. If visa stamping is not done, Your Lordship, she will lose the opportunity to rehabilitate.
Why do you say so?
5th visa stamping is required.
But if 5th is cancelled, it will be again visa date will be given. What is the problem?
5th has been fixed as an appointment. A confirmation letter has come to the.
Doesn't matter. When you go abroad, what is the procedure? You are called for an interview. And upon that, you are granted the visa for the prescribed period.
Your Lordship.
We will enlist it, but in the absence of the mother, we will not hear.
We will serve the copy, Your Lordship. Kindly grant us the leave, Your Lordship.
File it, give the number to my court officer.
Your Lordship.
And give us notice. In hard absence, we will not pass it.
Lordship.
This is granted. On tomorrow, don't say we have served, complete, finished. We are not doing anything. You ensure that the mother appears.
Your Lordship.
Much obliged, Your Lordship. Permitted to mention upon notice 2 matters of the combined list for upgradation, my lord, because contempt application is.
We have 10 working days, sir. We have so many fixed matters.
My lord, any day in the supplementary list, because Your Lordship kindly appreciate my difficulty. My lord, there is an order of reinstatement by the Honorable Justice Sen Gupta, my lord, and contempt application has been filed by them. I'm for the appellant. 2 BSF personnel has been caught red-handed in cattle smuggling. Short point involved, my lord. If you upon notice, I'm any day.
Prior to vacation, we don't think it will.
Then my lord, kindly fix any day after vacation also, my lord.
So you mention on the reopening date, we will.
My lord, the learned court is not giving adjournment, Justice Sengupta, my lord. This is very difficult.
Very good. When is the content fixed? You pray for an adjournment and
it is running in the.
When it is the next date fixed?
Friday.
Which Friday?
My lord, coming Friday is the date. He's taking contempt matters on Friday.
First time it is appearing.
No. It is appearing earlier also. I paid for adjournment. And here my junior also mentioned this matter.
Mr. Mitro, you have to wait.
Any day, my lord.
For adjournment.
With folded hands, I am praying, my lord, any day. My lord, before vacation.
Yes.
My lord, seeking leave to move habeas corpus application, my lord, it relates to COFE POSA. Now, the detaining authority has detained this applicant, this detainee, without safeguarding the section 3 subclause 3 of COFE POSA. My lord, this I need to move it as urgently as possible tomorrow.
No, file it will appear usual course on the returnable date.
My lord, we will serve all the respondents are from Calcutta.
Come upon service day after tomorrow, 48 hours notice you give the number to my court officer.
Day after tomorrow. Day after tomorrow, my lord.
48 hours notice you have to give. You have to write down the returnable date.
My lord, may I permit to mention one Central Administrative Tribunal matter, my lord. There was a direction, my lord. The petitioner is not getting family pension, my lord, since 2007, my lord.
Which matter are you mentioning?
Which Central Administrative Tribunal. Central Administrative Tribunal.
Is it in the list?
Yes, my lord. No, that has not been listed. But file has come. I have already mentioned.
It will be listed. Don't worry. The other number near now combined listed the other way.
Yes,
9th.
My lord, my lord,
it appeared first. Yes.
Yes, my application for mentioned by inclusion of this, my lord.
Include what application?
Yes, my lord.
Give the slip.
2 applications.
This is WPC the 130 of 2022. The Division bench did not grant any interim.
It is, what do you want, Mr. Das?
My lord, let it be listed, my client's salary has been stopped because of pendency of the WP. No stay is there, my lord.
It will
During the.
near now, 9th listed the other. Yes.
My lord, application for contempt, my lord, to analogous.
Contempt of which court? Our order?
Yes, my lord. Yes, lordship judgment. My lord, lordship judgment, my lord.
Chief Justice
Yes, my lord.
Chatterjee.
A first appeal land acquisition matter, my lord. Your lordship passed the judgment enhancing the land value of the land acquisition judge and also directed to pay the compensation to the landowner, my lord, within 3 months from the date of judgment. But in spite of that, the collector alleged contempt is not paying compensation.
Contempt heading and the other way combined list. Yes, give the list. Yes.
But I'm
Supplemental list.
I mentioned urgent matter, my lord, we are directed to serve notice upon the opposite party.
Which matter?
Matter is, my lord, petition is a serious ill, my lord.
Which is the matter? Is it in the list?
Upgradation, my lord.
Upgradation.
Yes.
What is the
Item,
urgency?
Rounded, my lord, petition is still not without pay, my lord, since long, my lord. Petition is suffering illness, serious illness, he is medically decategorized by the respondent, my lord. He made a VR, my lord, but VR is not accepted, my lord. Cat rejected my prayer, my lord. I can come, my lord. Reply of all.
Is it in the combined list?
Yes, my lord.
What is the item
Item
number?
195, my lord.
195.
Yes,
It
my
is
lord.
hearing matter.
Yes, my lord. All are complete, my lord. I am serving notice, my lord. Kindly have.
Let it be in the list. If it is on regular turn, we will be.
My lord, previous occasion I mentioned, my lord, but honorable your lordship directed to serve notice and
This is a hearing matter. Prior to vacation, it may not be possible.
kindly allow my.
Remind us if it is not
Kindly
reached.
have the matter, my lord. I serve notice, my lord.
Remind us it is a hearing matter. If it is reached, we will take up. Otherwise, remind us on the reopening. Yes, yes.
May I permitted to mention one matter, my lord, for inclusion, my lord.
Give the slips, give the slips.
Grateful,
But,
my lord.
There are two matters, my lord, land loser matter. I'm affirming it today and filing, my lord, may it come up on 5th, my lord, your lordship is.
First you file, then you mention. What is this, Mr.
No,
Sahu?
because, my lord, urgency is, my lord, otherwise,
First you file, then mention.
my lord,
Yes.
we'll file it, my lord, lordship will kindly direct your lordship's court officer to take the slip, I'll give the number.
When we have made it returnable.
5th.
Huh?
5th, day after tomorrow, my lord. At 2 PM, your lordship has made it return.
To file it first, then
My lord, I'll give the slip and I'll give the number.
Lord, may I permit?
without the number, my officer will not in.
I'll give the number. I'll give the
My
number.
lord, may I permit you to mention?
I'm
one
grateful.
Service matter, my lord. My lord, petitioner was dismissed from service, my lord.
But it is new matter.
New matter. For inclusion, my lord.
Or
As a-
yes, give.
Lordship, may I permitted to mention last Friday, Mr. Subroto Mukhopadhyay is mentioned the matter before your lordship, and your lordship was directed to mention the matter.
What is the matter?
Matter is the lordship
Which
urgency.
is the item number?
Lordship, the matter is not in the list.
If the
But
slip, it will appear. Yes.
lordship urgency,
First, let it appear on 9 there.
May I kindly
Combined
be permitted
list
to mention this matter, my lord? This is for inclusion in the list. Contempt.
the slip, give the slip.
My lord,
Yes,
a contempt proceeding is pending, my lord. The next date is 13th of October.
13th of
13th of October, the contempt proceeding is going on, my lord.
it in the list. Is it in the list?
This matter, the appeal is not in the list, but the contempt is proceeding, my lord.
No, you have filed. It is a WPCT matter.
No, this is MAT. This is intercourse mandamus appeal, my lord, and this is a service matter under Group 6.
What has been?
It was supposed to appear in the list on 30th of September, my lord.
We passed any order.
No, my lord, it did not appear, and I'm mentioning it.
Motion stage. First
It
time
is it will be appearing first time. Till date, it has not appeared.
So why didn't you take steps earlier?
My lord,
Did not tell us earlier that contempt is fixed. Please take up the matter.
my lord, I followed up with the court staff. They said it will appear eventually, my lord.
Yes, it
That
will
is my
appear.
mistake.
It is in the. It will appear in the combined list. On 9th, it will appear in the combined list.
It will appear, my lord. May I submit? May I submit the list?
Yes. Give the
Lordship, may I
slip on
submit
9th.
only one thing?
Just call the list.
Lordship, may I submit only one thing? That matter. Lordship,
Let it appear in the list first. Thereafter,
Lord.
combined list dio. Yes. Call the list.
I'm appearing for state
Three.
lordship.
Whose personal appearance?
Lordship, the father, biological father was supposed to come down today.
Who is the petitioner?
Petitioner is the sister of the biological father.
Hmm. Then we asked you to ensure the presence. Huh? You have not.
Last order, Lordship.
Where is the petitioner?
Directed
Was this order
immediately.
intimated?
Lordship, the IO is supposed to come down. He said that he's on his way. He's just. He's. Lordship, the father is here.
Hmm. You remind us what is the matter?
Lordship, here the child was growing up with the sister of this biological father. Subsequently, the sister asked the biological father to make a birth certificate. Then the father informed the home and gave the child to the home. The child is staying with the home now, and the biological father is refused to take the responsibility of the child. So, Lordship, in the last
So has he married? Married?
yes,
thereafter?
someone else, not
Someone
the
else.
biological mother.
So who is the biological mother then?
Biological mother,
Is she a party here?
just a minute.
The petitioner is.
No, I don't think so, Lordship. Biological mother is not a party in this
Will you
proceedings.
please ask
She
him
also
why,
has.
why he doesn't want to take the custody of his child? বাবা রিফিউজ করছে নিতে custody.
বুঝতে পেরেছেন? আমি ড্রাইভারি করি, মানুষের সাথে কথা হচ্ছে না, ফোন ব্ল্যাকমেইল করছে। ওই আজকে এটা দিতে হবে, দিয়ে যাচ্ছিলাম, টাকা পয়সা দিচ্ছিলাম। তারপরে মানে 5 বছর থেকে 5 লাখ টাকা দিতে হবে, প্লাস আমাকে হুমকি দিয়ে থানায় গেলে থানার বড়বাবুর সামনে বলছে 5 লাখ টাকা দিতে হবে, আর প্রত্যেক মাসে 8,000 টাকা করে দিতে হবে, ইংলিশ মিডিয়ামে পড়াবো। তাই জন্য আমি বাচ্চাটা ভালোর জন্য আমি ওইখানে দেওয়া হচ্ছে।
Lordship, what he's saying that the petitioner is blackmailing him. So that is the reason he has given the child to the home, because petitioner has demanded for 5 lakh rupees and around 8,000 a month for the maintenance of the child.
Why petitioner is claiming money?
What this
Now
is
petitioner want
the
of
custody.
the child.
Yes,
They have brought up the child as their own.
yes. And here the father has given the son to the home just because of this demand, what he is claiming.
Who is for the petitioner?
Now
Abil Nasir.
girl is with the home.
Home. This is a son. This is a son, boy,
What is the age of this?
7 years.
Surprising why the petitioner is not here. But that is instance also, no?
Now, if the couple wants to take adoption of the child, father is agree without making any demand.
হ্যাঁ, ভালো মানুষের জন্য আমি দিয়েছি, না তো আমাকে না কেননা আজকে না 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 এছাড়াও আমি অন্যজনকে দিয়ে কিন্তু এটা 6 বছর ধরে আমি
আরে বাবা টাকার কথা ভুলে যান আপনার বাচ্চা যদি টাকা ছাড়া ওরা যদি কি আছে?
না বাবা ম্যাডাম কিসের জন্য আজকে ধরুন আমাদের বোন নিজের না না যদি যাই না মেন ব্যাপার আবার সেই টাকা পয়সা আমি কথা বলছি না আবার আসবে আবার এটা নিয়ে এটা নিয়ে। বুঝতে পেরেছেন? ওই কারণে হ্যাঁ আপনি অন্য কেন ওদের যা পরিস্থিতি ম্যাডাম মানুষ করতে পারবেন অর্থ হচ্ছে বড় একটা বাচ্চাকে মানুষ করার জন্য অর্থ দরকার
He's
They are
saying
not
that,
so financially affluent, the couple.
yes. He's saying that,
Say that if the child is kept in the home,
Hmm.
then home is not keep his custody for long.
yes,
What home will do? One asks the biological parents and asks whether you want to take custody or not. If biological parents will no, then they will declare they legally free for adoption. Then through online process, you know very well, another person will take adoption of the child.
he's saying that he's not ready to take the child. He's not financially capable since he is doing a job of a driver. So,
He,
what
You're
he,
claiming money to take the child.
No, Lord.
All right, take your seat. Get back your breath. Take your seat.
so he wants the child to be given in adoption to someone else, not the petitioner. Because he is scared that
as per Juvenile Justice Act.
one, that the petitioner is not financially capable, and the second, he is scared that this asking of money can again occur after he gives the adoption.
আমরা তো ওকে চাইল্ডটাকে ওর হাতে দিয়ে দিতে তো আমরা বলতেও পারি ও তো চাইল্ড ওয়েলফেয়ার কমিটির কাছে আছে ওরা যা কি অ্যাপ্রোপ্রিয়েট অ্যাপ্লিকেশন জিজ্ঞেস করবে যে
কি বলবে একটা সময় আসবে তো একটা কোনটা যেটা এটা বলুন তাদের এগুলো লিখে কাজ করতে দাঁড়া এই যেটা 5 এই যেটা
Yes.
The child was in my custody since the child was 2 months old till he attained the age of 8 years. We never claimed anything. But now
তোমার এই যে লিপিকা যেটা এটা দেবস্থাকে দিবি
Yes, tell us.
I'm led by Mr. Sinha. My lord, we are not asking anything. We are only asking for the child, my lord, nothing else. Our only prayer is that, my lord, that we are the foster parents of that child. From
Father says you are demanding money.
we are not demanding anything. My clients are ready to file affidavit before your lordship. We don't need any money. We are only asking for the child's proper adoption, my lord. Nothing else.
For that you have to settle with the biological father. You have to say, because under the Hindu Adoption Act,
Yes, my lord.
you need not go to the juvenile justice procedure.
We have not gone there.
So, right, what is the
He is
option?
not ready to give it. That is the difficulty, my lord. He is ready to send it to some place else.
He is ready, he says.
If he is ready, my lord, if he is ready to, my lord, say
Coordinate with the father, sit with the father, settle the issue.
we are ready to settle the issue.
To settle it.
Ask
My
him
lord,
whether
one
he
more,
by
my lord, one more thing, my lord.
executing
But I-
of adoption. Ask him whether he by executing a deed of adoption will give adoption to the child to the couple.
সেই লিবার্টিটা কোথায় গেছে? এটা কোথায় সেই জায়গাটাতে?
না না ওরকম আমি দিতে চাই না আমি দেখছি প্রত্যেক মাসে মাসে টাকা পাঠাচ্ছি ম্যাডাম বছর ধরে টাকা পাঠাচ্ছি ওদের অর্থ কি আছে একটা বাচ্চাকে বয়স করার জন্য steps তো লাগে ওইটা না আমি বলছি ওদের যে ওরা যে মানুষ করবে ম্যাডাম, একটা বাচ্চাকে মানুষ করতে তো অর্থ লাগে, কি কাজ করে ম্যাডাম? যে ভ্যাকেন্সি
Lordship, he's saying that the petitioner doesn't have any financial capability to.
Is he ready and willing to
No,
give
no,
the
he
child?
is, no, he's saying that since the petitioner doesn't have financial capability, he is not ready to give the child to adoption.
Not to keep the child, but to
Not
give
to
it
keep the child, not to give it to adoption to his sister. Someone else can take the adoption.
Why he is not agreeing?
Because
Why?
the petitioner doesn't have financial capability. This is what I am saying.
He's bringing up the child since 2 months old. Now what is his age? What is his age?
7 to 8 years.
7 to 8 years. Now for last 7 years, he has brought up.
Psychologically, he'll be very,
Kindly consider
very difficult for the
situation
child,
of the child, madam.
psychological. Yes, very difficult.
We
I
have
can say.
another daughter. We can survive probably, but kindly consider the son's position, my lord.
Listen,
Detainee
we
position.
cannot direct a person to give adoption to. We don't have the jurisdiction. We have to ascertain whether there is illegal detention or not. He is under the custody of the home, so he is not under illegal detention. So we requested you that you settle up the issue with the
We
biological
are ready to settle, but he is not ready to
Then you
settle, my
take
lord. What would
steps,
we do?
Then you have to take steps before the
Kindly
appropriate forum.
My lord, there is no other appropriate forum, because why, my lord, I'm saying this? Because now if I have to adopt through the, my lord, the juvenile justice and through the CWC, my lord, as well as, my lord, that procedure is entirely different, because we have to apply through online. And if somebody else has already chose that child, then, my lord, we won't get another this child. We will get another child, my lord. This is entirely a separate process. And, my lord, kindly consider that when it comes to 7-8-year-old, my lord, these childs were not, my lord, adopted by normal couple. These childs are most of the time adopted by the foreign citizens. They go outside India.
The Juvenile Justice Act এটা তো juvenile justice এর ইয়ে, এটা তো এখানেও minor।
অনলাইন পোর্টালে বায়োলজিক্যাল মাদারকে ডাকবে, লক্ষ্মী বায়োলজিক্যাল মাদার চাও কষ্ট ওরা বলবে
কি মানুষ করবে এতদিন পর্যন্ত 5 বছর হয়ে গেল।
Look, I am saying, now here in this habeas corpus petition, we are called upon to decide whether the custody of the child is illegal or not. Detention is illegal or not. Now it has come to us that child is now in the custody of Child Welfare Committee.
Yes, my lord.
So we are not in a position to hold that the detention of the child is illegal. Now it is the matter in between you and biological father. And on hence earlier occasion I said that you settle the matter.
We are ready to settle if somebody is not ready to settle.
But here we cannot act as an intervener only.
My lord,
Arbitrator.
kindly consider the
Okay.
plight of the child. He was from the beginning, he knew that we are the parents. Now after 7
Under
years,
which provision can we give you the relief? Tell us.
My
That
lord,
under
kindly-
this
my lord,
provision,
if he is ready to withdraw the, my lord,
we cannot force him to withdraw. Can we force him? Give us the.
kindly direct the home, that so that the home can, we are ready to do every proceeding which is the CWC
Listen,
asking.
home will not give it to you. Home will ask the biological mother and father to appear, and they will question, do you want to take back the child or not?
No, that part has already over, my lord.
So
They have
then
already given that they did want to.
So it will be.
Yes.
With the CWC,
Yes,
so if we can approach the CWC, if the CWC can, my lord, give that child to us, and for that, my lord, whatever procedure is required, we are ready to.
That means that's procedure over. That means they have got the message that the biological parents does not want to
Yes, my lord.
to take custody of the child.
Yes.
Now what they will do? They will declare that the child is legally free for adoption. and thereafter the particulars of the child will be uploaded
Yes,
in the portal.
About on to that.
Then the person who, the couple, prospective parents who are waiting to get adoption, he will get a chance,
Yes, my lord.
then you will lose the child.
That is the difficulty, my lord, which
And
which we are
hence,
facing.
hence we said on earlier occasion, you try to settle the dispute
But what would we do?
so that you can take adoption of the child as per Hindu Adoption Act.
Yes, my lord, kindly consider that before this court also, he is not ready to take.
We cannot force, we cannot order.
Kindly
We
direct
can,
the CWC so that we can, if we.
why it is not the duty of the CWC to settle the matter.
Now,
You settle the matter.
now there is nothing left to settle between us and the private respondent. Now it is between because they have already given the declaration as per Mara Rule 7. They have given 711. They have already given the declaration that they don't want the child. So now it is free for adoption.
Yes.
Now, if we apply for
You
adoption,
will not get. There is
If-
no
if-
certainty that
if
you
the
will
court
get
can
the child.
intervene and can say that this child can be given to us
Yes.
if he has or not already adopted.
That cannot be.
Well, kindly consider, kindly ask the child whether the child wants to be with us or not.
We cannot ask the CWC to act contrary to the guidelines of the CARA or act contrary to the Juvenile Justice Act. The many person are waiting in the queue.
Right,
You will get after 6 months, after 1 year.
Yes, that is the difficulty. But in between, my lord, that child can be given to some other person. And here the situation is
But which provision it will be given? You are a council, argue on the basis of
my lord, this is entirely, my lord, for,
we made an endeavor, we called the
this is
biological
entirely
father.
for a humanitarian ground, my lord. I know that, my lord, there I cannot cite any law for that. But kindly consider the plight of the child.
ভেকেশনের পরে রাতে CWC কে তো 1 মাস রেখে দিতে হবে child। ছাড়া তো কিছু আছে দেখুন।
ব্যাপার থাকে
দাদার কাছে আনতে পারবেন মানুষ হসপিটাল
At best, we can adjourn the matter, fix it after the vacation. You settled in the meantime. Even we cannot ask the CWC, don't take the next follow-up step.
My lord, kindly
You are
consider,
to-
my lord, kindly consider the
You are
situation of the
to-
child.
You have to convince this person.
We are not.
You have to convince this person, you have to convince, they execute one deed of
difficult.
adoption in my favor so that I can get adoption of the child as per Hindu Adoption Act. Otherwise, as per Juvenile Justice Act, he will proceed.
But
My CWC will proceed.
kindly consider one thing, my lord. Today, the biological father has no right because as per section 7, my lord, he has already given the declaration that he don't want the child. So today, if he wants to give it to me, then also he doesn't have the power.
Now the ball is in the court of CWC.
So that's why, my lord,
We'll do whatever.
that's why, my lord, that's why, my lord, adjourning this matter after vacation,
In the circumstances, we are.
my lord, kindly consider that the child is with us from 2
liberty
months.
to approach the appropriate
Appropriate-
authority in accordance with.
My lord, the appropriate authority, if I approach, my lord, we are not ready to adopt any other child. Kindly consider. This is a child which was with us for 7 years.
You
And now suddenly, my lord, they just,
we understand your anxiety, we understand your anxiety, but how can we help you? We insisted that you settle it. With
kindly,
him. If
kindly
you
then,
cannot settle, we have to pass a judicial order.
my lord, before we approach this court, the settlement part has already over because he has already given that.
Very good, then we are passing this order. What
My lord,
can be
kindly
done?
direct the CWC. Till we approach the CWC, they should not send this.
We'll give you liberty.
No, till that point of time, my lord, let the child be with them. Because in between, if they send it for adoption,
You, along with your order, you go and approach CWC.
Yes, but in between, my lord, if I approach, suppose, my lord, we approach day after tomorrow, and tomorrow they send it to some.
So what we will do, we will ask the police to tell the CWC that keep the child as long as you want.
No, not as long.
Get the order copy, you approach them tomorrow.
But my lord, the difficulty is that they are going to say that no, you have to wait in the queue.
For that you have legal remedies available. What can be done? In habeas corpus, we cannot help.
My lord, there is no other subject to correction, my lord. There is no other remedy, my lord, that where I can say that CWC will give me a priority. My lord, they will say that you have to wait in the queue. After 1 year, when your number will come, then we will consider your application. Kindly give me that priority, my lord. Otherwise, my lord.
Father has an advocate, Miss Mulli.
No.
এদিকে আসুন, এদিকে আসুন, ওদিকে যান,
Story, my lord. But there is nothing, we are not demanded a single penny from him. He cannot keep the child because that child is coming from an illicit relationship with somebody else. He is living with his first wife and daughter. That's why he sent that child to us. There was a settlement between that lady and this biological father that he will raise the child.
Now that option is over. He is not willing to give it to you. Money, no money is in.
I am not asking from him. I am just requesting.
We
kindly
cannot force him. We cannot force him to give.
It is now not on his.
Alright, we have
Kindly
heard
consider that, my lord, that he has already given the declaration that.
We have heard you. Yes.
My lord, kindly give us some priority before the CWC, my lord, so that, my lord, my application can be considered, my lord. Because otherwise, my lord, they will.
We have heard you, sir.
My lord, in other matters, my lord, I would not have, my lord, made this, after this, my lord, I would not made any submissions, my lord. But this is kindly considered the plight of the child, my lord. The 7-year-old child, my lord.
Yeah, B, not A.
He's staying with, your lordships can even ask the child to come before your lordship and ask whether he wants to live with us or not.
Appearing
Whether we have done anything wrong with that child or not.
the submit that
He's living with us for 7 years, my lord.
that the child,
Now suddenly he is in home.
that the respondent number 13 and one Mamuni Day are the biological parents of the child. Now respondent number now before adoption from school. Now the respondent number and the biological mother of the child are not on equal terms and they are living apart from each other and living separate from each other. ঠিক আছে? Now, respondent number 13 handed over the custody to the custody of the child to the petitioner when the child was of 2 months 2 months old.
What was the age when the child was handed over?
2 months.
2 months. And since then, petitioners have been bringing up the child. And now the child has attained the age of 7 years.
Well, kindly see page 22 onwards once.
Suddenly, respondent number 13 has forcefully taken away custody of the child from the petitioner and handed over the custody to the seller. He submits that considering the emotional attachment of the child with the petitioners and considering the welfare of the child, which is a paramount consideration, necessary appropriate direction should be given upon the seller to hand over the custody of the child to the petitioner. Appropriate direction should be given appropriate order should be passed. So that the petitioners can get custody of the child. So the petitioners can get custody of the child. Here is stop. In compliance with our earlier order, earlier order dated 18 September 2023. 2023. 23. The biological father of the child being respondent number 30 is presently present.
Child হচ্ছে 14/12/2015 ওই সময় বানানো আছে তখন তো মানে 1.5 বছর বয়স
And we are stated
বিয়ে হয়েছে 21-এ বাচ্চা হয়েছে 1 বছর টাইম দিতে হবে
take custody of the child. And he has made such a declaration to the CWC also. Mr. Chatterjee, learned advocate appearing for the state, Mr. Learned advocate, additional public prosecutor, appearing for the state, submits that a child is now in custody of Child Welfare Committee, Kolkata. Let the report as produced by Mr. Chatterjee with the report. A writ of habeas corpus in which the cause and justification of detention of any person is inquired in in a summary proceeding. Stop.
Reading the nature of legal, with a read in the nature of certiorari right. A read in the nature of habeas corpus is a prerogative writ, by virtue of which the causes and validity of detention of a person are investigated by a summary procedure.
Stop. From the report and from the submissions made on behalf of the respective parties, it appears that the now child is in custody of the CWC Kolkata. Stop. And CW and such custody can never be held to illegal detention. Stop. View thereof, no interference,
No further
interference is called for in this writ petition. Consequently, the writ petition is dismissed. However, it is clarified that this order shall not preclude the petitioner from approaching the appropriate authority in accordance with law.
My lord, for adoption of this child, kindly mention that, my lord. We don't want any other child. Kindly consider that, my lord.
Sure.
Kindly consider that aspect, my lord.
Yes, next matter.
If the liberty in respect of only that child, my lord.
We have not answered that query of yours. If we deal with it, will go against you. We have discussed the matter, the issue has been kept open. Yes.
Hence, on earlier occasion, we said they settled the matter.
My lord, settlement cannot be possible.
We cannot ask the CWC to act contrary to the declaration given by the biological parents, biological father.
If today he is not ready to give it,
Yes,
when we
next
file it,
matter.
before that he handed over to the CWC.
You tried your best, sir. What can be done? Yes,
Tried your
next.
luck.
My lord, kindly grant that liberty, my lord. Otherwise, my lord, we won't get the opportunity, my lord. After 1 year, we will get the queue.
Yes,
Your lordship
next.
knows, my lord. Kindly consider that aspect, my lord. Kindly consider the plight of the child.
Yes,
It is
next
ultimately
matter.
for the welfare of the child, my lord. My lord, the state is also not opposing, my lord, if your lordship kindly.
Huh?
They are representing the CWC, my lord.
It will do. And there's a Lokki Pandit judgment. First, the CWC take view of the biological parents. Then they act.
That part is over, my lord. Now today they cannot, my lord, kindly.
We have heard you. We have heard you. You tried your best. We have spoken through our daughter. You take appropriate steps. Yes.
I'm grateful.
Yes.
I appeal for the private respondents. I do.
Private, who is for the petitioner?
Item number 4. My lord, item number 4, I'm appearing for the petitioner.
Yes.
May I please my case, my lord? My lord, I got married to Barkha Jhunjhunwala on 21st January 2020. Thereafter, on 30th May
You are the
2000,
father.
I'm the father, yes, my lord.
And who are 3 and 4?
My lord, I'm appearing for 3 and 4 is the matter.
Who are they?
They are the uncle and the
My brother-in-law.
brother-in-law, the brother-in-law and sister-in-law, my lord. My child is
Age
with
of
them,
the child?
2.5 years.
Huh?
2.5 years.
Female or male?
Female. Female, my lord.
Mother has died.
Mother has died.
Then your
My-
father is residing with whom?
The father is residing with his family, his father and his brother. His sister resides.
So why did you give custody to
My
them?
lord, what happened is, my lord, when my wife died, the family was facing some crisis. During that time, my brother-in-law suggested that they will take care of the child for couple of weeks or few months, and then as and when I make necessary accommodation, I'll be able to. My lord, I'm led by Mr. Banerjee.
Well, this is the matter, my lord. I said
You take your seat. Yes, Argu. Argu.
My lord, what happened when my wife died? They have taken the child to take care of the child for a couple of weeks or a month. As in when I'm
When
able
was the child taken away from you?
on December 2022, right after my wife died.
Then thereafter you lodged any police complaint?
No, my
No, my lord.
Lodged any police complaint? What is page 28? Annexure P5?
My lord, we went to the magistrate, my lord. There is an
SDO.
application, SDO. We made an application to the SDO to provide us police assistance so that we can get the child back.
What do you do? What is your
I-
profession?
My lord, I'm an accountant in a company.
real estate developer.
Do you
Real,
have any other children?
no, my lord, this is my only child.
You are an accountant.
Account.
And what does the uncles do?
Business.
My lord, they have a business. They are running business.
They have a business.
Yes, my lord.
Yes,
My lord, only thing, my lord.
yes.
My lord, there is no dispute as such, my lord. We don't want to keep the child forever, my lord. Now, what has happened is my sister's daughter is there. She's 2.5-year-old, my lord. They reside in Patna, the entire family. There is no male member in the petitioner's family, my lord. Petitioner resides with his father, who is also, my lord, what I believe, my lord, subject to correction. He has suffered a major accident and he's partly, my lord, paralyzed or subject to correction. There's something which is suffering. Now, my lord, the child was taken with the consent of the father. She is 2.5-year-old, my lord. We are only, my lord, the only concern is, my lord, let her grow, let her be capable of at least taking care of herself with regard to the basic needs. Now, if your lordship kindly comes to page 21, they have written us a letter. We have found a nanny who will upbring the child. Kindly return the child to us. Child right now is with us, my lord. He is with the sister's brother-in-law's wife and parents, my lord. My lord, your lordship will kindly consider, my lord, the atmosphere at
They are residents of Bihar.
Bihar.
They are residing in Patna, my lord.
You are residing at?
My lord, Patna. We are residing.
Also at Patna.
Yes, we are in Patna, my lord. The respondent number 545 and the mother's, the deceased mother's brother.
Then why the petition has been filed here?
My lord, that is,
The petitioner is in Howrah. He resides in Howrah. Petitioner resides in Howrah.
petitioner is here.
Not resident of Patna.
No, my lord.
So the child was taken away from your residence at Kolkata.
Patna, yes, my lord.
It was by consent, not, my lord, because of your lordship. Kindly see the letter, my lord. It's not a, it's not a case when there's a, my lord, we are at loggerheads or there's dispute, my lord. Paramount consideration is the child's welfare. We also understand, my lord. Child is very happy with us, my lord. Now they say, give me the child. I have found a nanny to take care of the child. Who will bring her up? Father leaves for his job.
So you assist the father. You are
My lord, we
the-
have, my lord, in fact, my lord, what we were suggesting, subject to what falls from your lordship, my lord, it's, my lord, he is also entitled to this right.
the first right. of-
Yes, yes, my lord, I bow down, my lord, we are not disputing that, my lord.
When you are not disputing it,
My lord,
you provide financial assistance.
my
to
lord, only
your-
one thing, it's not about financial assistance, we'll do it, my lord. Only thing is, my lord, accustomed. If the child gets accustomed, my lord, what we may suggest, my lord, we are not saying we will not give back, my lord. Our only thing is, my lord, the child is 2.5-year-old. He's only made 2 visits in the last 9 months, in the last 8 months to see his child in Patna. My lord, if he starts, my lord, in 4 weeks, let him get accustomed, my lord, with the child, my lord, because with the child will go in a very unfamiliar, my lord, environment. 2.5-year-old daughter, my lord, and father will leave for work, my lord. There is nobody else at home then. My lord, our consideration is also the well-being of the child, my lord.
You settle with the father.
My lord, we are willing, my lord. We are willing, my lord. We are not, my lord, we are not saying we want to hold back the child, my lord. We are only concerned with the,
Hand over, hand over.
my lord,
Hand over.
Hand over, sir. He is the biological father.
my lord, that we are not, my lord, I bow down, my lord. We are not, only some, my lord, some, only the child's, my lord.
More we keep, there shall be more emotional attachment. Kindly hand over. You have to give, so give it now. Okay, now he is
My lord, can we,
2 years, 2 years.
2.5 years.
2.5
my lord.
Adjust.
My lord, only one thing, if we can work out the modalities between us, my lord, instead of,
We
my
will
lord.
give you visitation rights.
My lord, that is exactly, my lord, if we can sit down and if we can work it out, my lord, with the,
We are working it out for you. Take the trouble. We
My
are
lord, may-
working it out.
my lord, may I just,
Yes.
my lord, our concern is the visitation rights, my lord, that because since the child will be coming up under the custody of a nanny, my lord,
We will give you visitation right. And if he misbehaves with you, we will give you the protection. Approach the police authorities. He will take steps according to them.
my lord.
Your concern is the child. We
lord.
understand that. You tell us what visitation right you
My
want.
lord, we want, my lord, unrestricted visitation rights to the child, my lord, one thing. Other, my lord, in long weekends or if something it works out, my lord, we can take back the child for a few days.
Allow the child
My lord.
to develop some attachment.
Yes,
with
yes, my lord,
her
that is, my lord,
with the family of.
my lord, that is, my lord, it's a natural right, my lord, even,
Interfere again and
my
again.
lord. No, there's no
Again,
interference.
again.
No, my lord, that is why I said, my lord, his prayer is also a very just prayer, my lord, is about balancing of the rights, my lord, because ultimately it's the paramount consideration of the child, my lord. That is what we are concerned about, my lord. We also want the best environment for the child. We don't want to keep her. We don't want to take her away from him, my lord. He also has that right, my lord. We acknowledge that, my lord. Only, my lord, the thing is, she is small and there's no female member there. That is our concern, my lord.
Settle করে দিতে হবে। Visitation right. Female member কি কাজ করে কি? বাচ্চাটাকে
সেখানে এসে কিছু ব্যবস্থা
How much do you earn? How much do you earn?
Take home salary.
Hmm?
About 1 lakh.
All right, 1 lakh month, take home 70. So 3 goes, sir.
Is there any female member in his house?
No, my lord. No, my lord.
How he will?
My lord, we have kept someone to take care of
The
the child.
child will grow up with your servant.
No.
See, he has no other member in his house.
His father is there, my lord. His brother is there, who is much younger. His brother is there, who is much younger.
They live in a joint family.
They live in a joint family, my lord.
Is there any female member in your family?
No, that is only a concern, my lord. Because
Female baby. Female baby.
Female baby.
Female baby.
my lord, there's
My
no
lord,
other
he
reason
has
for us
one
to do that.
sister who resides here in Calcutta. He has one sister who resides here.
She is not with you.
Both the
He
sisters are
goes
married.
out for work. Who will take care of the child?
My lord, the father and the brother is there.
And if father's brother, that vague statement won't help. Do you have your parents along with you?
Yes, parents, yes, my lord. My
Mother,
father,
mother,
my
mother? Your mother?
Mother passed away. My father is there.
Your mother has also expired.
My lord, long ago.
Then you tell us who will take care of the child.
The father is there also.
Mother is a working person.
No, father is retired. He's there at home.
His father.
His
No.
father is retired. He stays at home.
For proper bringing up of a female child, a
Yes.
female member is required.
My lord, we'll take care of
The
that.
male
my lord.
members have some limitation.
Yes, my lord. Agreed, my lord. We'll take care of that.
You consider.
My sister
will-
also resides nearby.
No,
Okay.
both are
Also
married, my
resides
lord.
Nearby.
Other
both are
will
married.
be able to do many things,
Yes.
but what mother do, father will not be able
Mother
to
is
do.
not there.
But mother is not there, my lord.
Eh?
Passed away.
Mother
Mother passed away.
My lord,
My
that is
sister
the only
resides
difficulty.
nearby. If that is a
My lord,
concern.
my lord, that was the only concern. My lord, if the child grows up, she understands, has a bit of science. My lord, she's too small, my lord. We don't want to hold the child back, my lord, out of. And he can have unlimited visitation right, my lord. And he's content.
You settle with them, sit with your counterpart so that they can willingly give you the custody. And if there is any acrimonious relation between the petitioner and his in-laws, that will affect the welfare of the child.
My lord, I completely bow down, my lord. The acrimony is developing because of this situation, my lord. There was no
Whatever
acrimony
it is, whatever it is.
developing because of this. Obviously, if the child was handed over willingly, there was no acrimony then. The problem is the change in stand. And my lord, I completely bow down. There is no
No,
female
no,
member.
he has
But
submitted
may I-
before
may I-
us.
Yes.
May I suggest something or subject correction, my lord? Let them let him have the company but custody temporarily for the time being. Let the matter be kept pending. Let us see how he's handling it. And at the end of the day, my lord, he's the father, he has a right and he has a duty also.
Very good, very good. That is a very good option.
My
Then
lord,
we'll
that is
come
why I
back after some time and see, because my lord, I bow down, my lord, the only thing important is the welfare of the child. You cannot play, my lord.
Now, what my brother has said, that suppose I have my aged father at home. We both are, I have to go for what? I have to leave the child in the custody of my father or a maid or an assistant.
Both.
So,
Both.
so don't you consider that the
That is why, my lord, I was
enactment
suggesting.
with
But
the
And in the day, my lord, he's a father. He,
No, we understand that. Till 6 years, the mother has expired, he has the preferential right. But the thing is, the question of welfare determination, we have to ascertain because we are in writ court. Otherwise, we would have relegated you to the common forum that go and give evidence and find it out.
my lord, may I, my suggestion subject to correction, my lordship.
We are keeping it after vacation.
My lord.
You ask you sit with
My lord,
him,
that is what I was suggesting. If
sit with
something,
him and don't prevent him from
never
going
we
and
have done it.
visiting the
My lord,
child.
never we have done it. And we also want, my lord, he visits. We are open to it,
So
my lord.
you keep the child, you also tell the
My lord.
child is 2.5 years.
My lord, that
na?
is-
You
my lord.
have a longing for the child, but once she matures,
My lord,
it will
that-
be more difficult.
We
for
want to give her back to him, my lord.
Longer she
We-
stays, it will be
My lord,
difficult.
but the petitions cases, my lord, the maid will bring her up, my lord. That is our only
My
concern.
lord, that is
When
one
it's about legal heirship, the property, you have to think. Yeah.
My lord, as of now, we are thinking, my lord, if the child matures to that,
She's 2.5
2.5,
years.
my lord,
So
2 years, 4 months.
Has she been admitted in any school?
She will be, my lord, because the age there, when they put her 2.5 years, this is the time, my lord, she will be admitted, my lord. Now they will take the steps to admit. Already admitted now, my lord. That is what.
Wait.
I do not know how they did that.
In the play school, they have put her, but not in any. In the play schools, my lord. That is.
What is the distance? Oh, you are in Patna.
Patna, my lord.
The learned advocates appearing for the respective parties submit that there is a possibility of settlement in the present matter. Stop in view thereof. The matter stands in view thereof. The matter stands adjourned. Leaves the matter for further consideration in the daily supplementary list of this court on 28th November. On 28th November.
8 minutes.
What you have done? You have filed any report?
No, my lord.
28th.
They never approached to the government authority except SDO.
28th November is it? You
That's
first sit with
97.
your friend.
My lord, I will sit with my
Today,
lord, friend.
video service file with Captain. You sit with him.
My lord, I will.
You work
We will.
out the modalities.
My lord.
In the meantime, if he wants to visit Patna,
Unrestricted, my lord. He can stay with us
Yes.
also, my lord. There's no
see
problem.
that it doesn't go out of
No,
hand.
no, 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 my lord.
Suppose he goes to Patna and something else happens.
No, 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 no. We have never done that, my lord. We are always open to it. We invite him.
We
Please
are
come.
imposing our faith on you.
My lord, absolutely,
Cannot
my lord.
impose faith
My
upon the
lord.
client just at this stage. When you are responsible counsel, see that the matter
My
is
lord.
sorted out. You claim your visitation right. Assist him if he is in monetary problem. You can suggest also that ask your sister to stay at your place for few months so that the child can be the modalities.
My lord, the environment has to be, it has to be made, my lord.
But the law is against you.
My lord, I completely,
Custody
my lord.
has to be with
My
the
lord.
natural guards. Sit and see if you can settle.
My lord,
Yes,
grateful, my
next.
In the meanwhile, my lord, he can visit the child.
Yes, it is understood. If he visits,
Yes,
you
yes,
allow
free.
visitation.
We are allowing that, my lord. You're not grateful, my.
Yes, next.
Visitation will be in Patna or shall the child be brought here?
No, you
No.
go to Patna. Shifting the child from Patna.
Very well.
to here.
We'll come back on 28th, my lord. By that time, hopefully, my lord, will.
By that time, you sit with your friend, work out the modalities, specify the date when he would be visiting his child. You intimate that thing. Let him go and visit the child. But see that nothing untoward happens.
My lord, nothing
If he
has
goes
happened.
there and if he
My lord,
does-
nothing untoward has happened. We invite him, my lord, and he'll be happy to see the child's progress,
If
my
there
lord.
be a
As a
cordial
father, he'll be
relation-
very happy, my lord. I can assure that.
at the instance of the child, the relationship be cordial. Yes, next.
Great.
Yes, 5.
I
I am for the
petition. Petitioner before your lordship is a homeopath doctor. He is the biological father. My lord, petitioner before your lordship is a biological father and homeopath doctor. My lord, page 80, kindly straightway come to page 80. straightway, kind Lord.
No other document.
No, my lord, first, my lord, page 80, the order passed by the learned district judge, Bardhaman, additional district judge, Bardhaman, first court.
Eh.
My lord, it is a ex parte order. My lord, page 81, custody of the child in favor of the petitioner.
Yes.
My lord, in spite of the order of passed by the learned, my lord, competent civil court, my lord, I made a representation. My lord, child with my lord, respondent number 8, Rupali Chaudhuri, the wife, mother. My lord, the date of birth of the child, my lord, 20th June 2008, now 15 years old. My lord, what has happened? Case and counter case in between the husband and wife is there. My lord, thereafter, my lord, the child, my lord, if your lordship kindly have a look into page 31, the application.
Your grievance is in spite of the competent court's order, they are not complying. with it.
My lord.
So you have the remedy available.
Have you bought the book, Guardian on WhatsApp?
I done it.
My lord, execution case, my lord,
Yes.
my lord, if your lordship, my lord, that is another, my lord, there's another possible, my lord, another 2 years time or 3 years time, my lord. For that reason, I have come before your lordship.
2 years time?
My lord, order passed, my lord,
21.
21. They
Why
are
didn't you go and file the appropriate application before the
that application, page 81, ex parte order.
Right. Now
That
you have-
application, they never appeared before the court below.
Mr.
And another,
Chakraborty, there is a procedure laid down under the act that if there is violation, what is to be done? How the writ court will help you. So, জেনে শুনে আমার মাথা।
and my lord, if your
Under
lordship,
Under section 25, 2 of the Guardians and
My-
Wards Act, you may make application before the district judge. District judge shall give you a search warrant to the police.
my lord, now,
Child will
my lord,
be taken custody and hand over to you.
the lordship kindly look into the affidavit of service. They have not come to here also, my lord. In spite of the order, the respondent, my lord, lady has a relation, extra relation with a person. Lady has a relation with a person, my lord. That is respondent number 7. দিন তো। He is an employee of, respondent number 7 is an employee of railway, my lord. He has a extra relation with respondent number 7. And I am a doctor, my lord. In spite of the order, it is true, my lord, alternative remedy is there, my lord. But in spite of that, but their parents, lordship kindly, I have served the copy upon the, my lord, wife.
জোরে বললে তো ভয় লেগে যাবে।
Efficacious remedy is there, not alternative.
My lord, if your lordship,
Mr. Chatterjee, a court has recognized that the child is now in the custody of the mother. Court has passed the order. One district court has passed the order. You have come here before the writ, you are filing writ of habeas corpus to enforce the order of the district.
You withdraw it, go to the district judge. File appropriate. That will be the procedure. Unless if you do not withdraw, we have to go into your arguments. Na? We have to go, that may be prejudicial to you or to the others.
then my lord, lordship kindly dispose of the application and liberty, my lord, kindly, if I file any application, kindly dispose of the said
And
application.
file the application first. What decide
Direct
you?
the learned, my lord,
So you
shall go to
withdraw-
dispose of the application within 3 months or 6
No,
months.
why? You have not even approached. Why should we say? You approach the court first. You withdraw the petition. It doesn't matter if you go there and you file the application. After that, if anything happens, remedy is available to you. Why you are unnecessarily wanting an answer to your question?
My lord. My lordship kindly, not withdraw, my lordship kindly dismiss my application. Otherwise, another problem, my My problem, withdraw then, my lord, written object, written instruction is required, my lord. He is a doctor, my lord. My client is a doctor, my lord. Otherwise, my lord, your lordship kindly fix the
Take
matter
the written
tomorrow.
instruction.
My lord.
It is not, we do not want you to be in problem. You explain to your client, come with the instruction, we dispose tomorrow.
My lord, tomorrow.
Or tomorrow. Come tomorrow. Explain to him.
Take back your book.
My lord, that is fine. My lord, may I submit the report or tomorrow?
Tomorrow you file. If Mr. Chakraborty withdraws it, then we need not.
My-
Yes, next.
আমার বইটা দিন।
Yes, correct. I am
রিপোর্ট করে রিপোর্ট করে।
Lord, an occurrence was made on 13 July 2023. Missing a minor child near about 14 years old. Lord, on 14th, I lodged a complaint before the local police authority. Police authority started a case under section 363, 365 IPC, being case number 250 of 2023. But the said child is not recovered till now. Not traceable, nothing is. And the police authority also not to take any
Yes,
steps
Mr.
for
Chatterjee.
recovery.
My lord, police had already taken steps, my lord. FIR was lodged under section 363, 365, and one of the co-accused was arrested, my lord. And the lady, the girl, the minor girl, has a love relationship with a boy, my lord. Both are fled away. Both are fled away, my lord. We need some time, and police, we have taken all the steps, necessary steps, my lord. The police.
Who is the boy? This Horipodo? Respondent number 5.
Boy, name. Horipodo, my lord, is the boy. And another boy, Rothin.
Whom did you arrest?
Rothin, another FIR name accused is there. He assisted them.
Oh, I see.
My lord, police filed the report and prayed for time, and they hope that the minor girl will recover.
Where is your affidavit of service? কিছুই দেয়।
Evidence service কে দাও না, evidence করে দেবো। সেলাইও করা হবে। তোমার কাজের পদ্ধতি রয়েছে।
What is the age of the daughter? Of your
15
daughter?
15 years.
15 minutes.
Ashok, Mr. Chakraborty, learned advocate appearing for the petitioner submits that the petitioner's daughter, who is presently aged about 15 years,
My lord.
went missing on and from 13th of July 2023. Stop. Such fact was immediately reported to the respondent number 3. Stop. Immediately reported to the respondent number 3. Stop. Such complaint was registered as Chandipur Police Station case number 250 of 2023 dated 14th July 2023 under sections 363, 365 of IPC. Stop. However, the police authorities have not taken appropriate steps and the petitioner's daughter has not yet been recovered. Mr. Chatterjee, learned advocate, advocate appearing for the state, submits that the petitioners submits that in connection with Chandipur Police Station case number 250 of 2023 dated 14th of July 2023, a co-accused, being the respondent number 5, was arrested. 6 was arrested and investigation is still continuing. Stop. In view thereof, list the matter for further consideration in the daily supplementary list of this court on 17th October. The police authorities are directed to make a sincere endeavor to recover the victim girl in the meantime. Stop. The investigating officer shall also file a report before this court on the returnable date, stating the status, detailing the status of the investigation. Yes, next.
Why the formal affair has been written in Hindi and English?
Chatterjee সাথে বলতো, let me report, comma, as filed, comma, be kept. এখন তোমার অনলাইন রেজিস্ট্রেশন ডিটেলসটা পেয়ে যাবে from সেই জন্য মাল্টি ল্যাঙ্গুয়েজে কেউ পারে।
My lord, I
am for the respondent in this matter.
My lord, this is appearing for extension of entry order, my lord.
My lord,
First entry order was passed, my lord, on 15th May 2023. Then it has been extended twice, my lord. Now this last extended, my lord, on 31st August 2023. And this will expire, my lord. This has expired, my lord. That expired, it was extended for 4 weeks. So, my lord, before that matter was mentioned. It expired on 27th of, my lord, 27th of September.
my lord, there is no merit in the writ petition.
Wait, Mr. Das. Yes.
It expired on 27th of September, my lord. It was mentioned on 25th of September. And when the matter was directed to be listed for extension of interim order. And the order dated, my lord, 31st of August 2023 is there, my lord. That extended for 4 weeks. And this matter was already heard at length by Justice Velumani. And then, my lord, my learned friend has not filed an affidavit. And now the matter should be taken up for hearing.
They are enjoying this interim order.
Was there any direction for affidavit?
You know, they didn't intend. They straightway argued the matter, and the matter was
Yes.
heard at length. My lord, kindly have a look, my lord. The order dated, my lord. My lord, order dated, that is Justice Velumani order, my lord, that was heard at length. This entire half day was taken. When my learned friend submitted, I on behalf of the petitioner submitted, then matter was fixed for further hearing. And then, my lord, interim order extended. Now, my learned friend never asked for filing affidavit in opposition.
Not required.
Yes, Mr. Das.
My lord,
We are not on merit.
my lord, tribunal has set aside the order of termination. The termination which they have made beyond the rules. And it is a stigmatic matter.
It's a date.
My lord, kindly see
Here you,
my
Mr.
lord, for a moment, my lord.
Das. At this
Only
stage,
1 minute, my lord, kindly. Because during the puja months, my entire family is suffering. The tribunal allowed the writ petition, my lord.
kindly come to the order of 28th June.
20th June.
As requested by Mr. Das, learned counsel for the respondent,
Yes.
post the matter after 3 weeks.
After?
3 weeks.
Yes.
It was your prayer the matter was adjourned.
Yes, today I am ready, my lord.
Today you may be ready.
My lord,
but we
kindly
have
see
to
what
hear the
happened.
matter.
My lord, if your lordship see, the entire action is beyond the rules. My lord, nothing is required. My lord, unfortunate lack of the petition.
Hear it, Mr.
My lord, kindly consider this aspect, my lord. The earlier division bench, presided over by Justice Holy Standard, my lord. I have cited the Constitution bench decision, 7 judges decision of the Honorable Supreme Court, that his order is patently illegal in respect of termination of the petitioner. By applying a wrong rules, my lord, they have done like this, the tribunal has set aside and quashed this order. And my lord, kindly see the last portion of this tribunal order. It is not harmful to the respondents, my lord. But during these months, my lord, entire family is suffering, my lord. They are enjoying.
Terminated on 13th July 2018.
Yes. Now this
Only 1 month you will.
my lord, kindly consider The matter was heard at length by the earlier division. Lordship, kindly
Mr. Das, have patience. It was at your instance matter adjourned. Matter is not that it appeared today only as a fresh application.
thereafter,
So don't
my lord,
argue. So do not reopen
what-
the argument at this stage.
my lord, when the matter was heard and fixed for orders, on that day my learned penal suppressed the crucial material fact.
Then where is your application for vacating the interim order?
But I want, my lord, let it matter be heard out only on the law points, my lord.
Yes, we will hear
It is
it.
covered by 7 judges with decision of the Honorable Supreme Court, my lord. I have already handed over to the court.
Upon
Kindly
hearing-
fix a date, my lord.
Come after vacation, we are fixing a date on that date. Don't
Upon
worry.
hearing the learned advocates and considering the materials, upon hearing the learned advocates, and as there had been no change in the circumstances, Upodili heard the learned advocates appearing for the respective parties and considered the materials on record. Next, as there had been, when did it expire?
The 27th, but it was extended for 4 weeks on 31st August 2023. It was extended for 4 weeks, my lord.
Then you are also there.
My lord, I am led by.
Upon hearing the learned advocates and as there had been no change in the circumstances, the interim order passed earlier is reinstated and extended till the end of, and extended till the, and is extended till 15th December or until further orders, whichever is earlier. List the matter. You will not use affidavits, Mr.
No, I have only on law points.
List the matter for final hearing
Absolutely wrong rules have been applied.
in the daily supplementary list of this court on 5th December. Yes.
Instead of fifth one, may it be sixth or seventh, because fifth one is usually.
My lord, not in the combined list, but in daily list, my lord.
আরে বলেছি সেটা list the
In
matter
December.
for final hearing in the daily supplementary list of this court on 6th December.
Six.
Yes.
So prepare come on that.
Item number 8.
Item 8. Yes, Mr. Bhattacharya.
The only question calls for your lordship's gracious consideration. My lord, I should be very fair to the court that what are against me. My lord, at the outset, I am telling you, lordship. My lord, a charge sheet is served on me in the year 2019. Just 7 days after the CBI files a charge sheet in a criminal case on absolutely similar facts, if not same facts, there are certain additional facts in the CBI charge sheet which is not a part of the departmental charge sheet. Now, my lord, in the CBI charge sheet,
CBI filed the case, what? Regular complaint was lodged?
yes, sir, on the basis of a complaint, my lord, on the basis of an investigation starting from 2015, my lord, it ended with a charge sheet in 2019. Now, my lord, the CBI charge sheet and the departmental charge sheet, the span is 7 days. The allegation is, my lord, disproportionate assets to known sources of income. Now, rightly, wrongly, what is against me, I am telling you, lordship. First, my lord, in the reply to the charge sheet, I do not ipso facto raise the point that you cannot continue this proceeding in view of the departmental, in view of the CBI charge sheet. My lord, thereafter the inquiry officer and the presiding officer is appointed. In course of the inquiry, I raised the point specifically, saying that this cannot go on because, my lord, I will have to shell out evidence, my lord, in the departmental proceedings, because, my lord, the CBI proceedings, the charge sheet is there, the charge is not yet framed. Charge is not yet framed, the trial has not commenced. Every, my lord, 6 months, 8 months down the line, dates are fixed. In the CBI case, it is in Bankshal perhaps. It is in Bankshal. Now, my lord, rightly, wrongly, the CBI case is going to take an eternal.
It has been fixed for framing of charges.
My instruction is, my lord, it is sometime fixed in the month of December.
I see.
But, my lord, ordinarily, my lord, it is my again duty to point out that the CBI charge sheet is dated 2019 December, and, my lord,
If my lord kindly sees the departmental charge sheet here, my lord, 27 December 2019, page 56 is the departmental charge sheet. Now, my lord, 19 December 2019 is the CBI charge sheet. Now, my only grievance today is, now, my lord, this inquiry, my lord, evidence has been laid. Evidence has been laid. The inquiry report has also been prepared, holding me, my lord, guilty of the allegation leveled against me.
So you preferred the original application challenging?
Challenging the charge sheet and everything. No interim order filed.
At that time, any inquiry report was prepared?
No, at that time, no inquiry report. I came to your lordship's court, my lord,
Now the inquiry report has been
yes.
filed. What is the date of filing?
My lord, the date is, just gives me a moment. You know, please come to the inquiry report. My lord, page 217. My lord, it is 17 July 2023. You know, it is at this stage that I have come to your lordship's court, because, my lord, the learned tribunal, my lord, was pleased to not entertain my original application. Though, my lord, this honorable court by an order kept all points open and left it on me, my lord, to urge it before the honorable tribunal.
Why?
My lord, I came to your lordship's court, my lord, alleging, my lord, non-grant of an interim order regarding the disciplinary inquiry.
Before a coordinate bench?
Before a coordinate bench.
Any order was?
Yes, yes. Just stand there. Just stand there. Just gives me a moment. But 386. I came to your honest, your lordship's court.
You came challenging refusal of interim order. That is
WPCT 30. Yes, yes. No, but not ipso facto refusal, I won't say. Against the continuance of the proceedings, if I may say so.
Very good. But what interim order you are seeking now?
Today, the position is, I have been served with page 217.
Inquiry report.
Yes. I have been called upon to respond thereto. I told your lordship, I have given a very cryptic response. Very, very cryptic, a one-page response by referring to my defense brief. I said I rely on the defense brief. These are the factual matrix in the defense brief. I don't raise any other issue. Wrong. But admittedly, a question of law which I seek to raise before your lordship is whether, on a careful consideration of the departmental charge sheet, the criminal proceedings, whether it was open to the authorities to proceed even with the departmental inquiry, because as I have understood the law, it cannot be indefinitely stayed. The departmental inquiry cannot be indefinitely stayed. But if the material evidence in both are one and the same, it is prudent that the departmental inquiry should be allowed to wait, directing the criminal case to not be wrapped up.
But Mr. Bhattacharya, that stage is over.
No, with respect, the issue is, that
today the refusal of interim order by the tribunal, you must have argued that don't proceed because the similar. Whatever it may be.
Maybe.
Now the interim order came. Court said that there may be they clarified that that was the observation of the tribunal.
Please see the order, which was
what protection you are wanting from us?
Today, this protection, I am getting my provisional pension. I have not got my other terminal benefits because the criminal case admittedly is pending. Today, kindly ask them not to pass any order in the departmental proceedings till conclusion, or for a limited period, expedite the criminal case or do something, because if today, ultimately, if I come, because in the criminal case, there is no charge sheet, and there is no charge. Charge has to be framed, evidence has to be laid. It will continue for the next 10 years of my life. In the meantime, what happens is, I don't.
Acting in your favor, they are concluding the proceedings.
They are concluding the proceedings. If today, kindly visualize this position. If today, by dint of these wrongly conducted proceedings, wrongly I say because legally it was not permissible for them to conduct the proceedings. Rightly, wrongly, at page 172, I have raised this point. They have not considered it. Please see. Yes. Yes. I'm sorry, 175. Now, this is in course of the inquiry.
ট্রাইব্যুনাল আমার দিয়েছিল আইও অর্ডার দিয়েছিল শত কমপ্লাই করে তারপরে IO shall be changed if requires.
Change করেছিল।
সেটাই তো চ্যালেঞ্জ করেছি।
Subject to the result of this.
Subject to result করে কি হচ্ছে, ফাইনাল অর্ডারটা পাস করবে। পাস করবে দিতে পারবে। To determine the basis of the negligence of the court at a final opinion. Then petition to the interest.
ভেবে লাভ নেই আমাদের।
Presentation দিতে পারি। এটার জন্য একটা সময় লাগবে।
Now, on this question, if your lordship wants, because kindly sees page 194 for a moment. In course of the proceedings before the learned tribunal, this was the order made by the learned tribunal, which was carried before your lordship's court in that WPCT.
I see.
This is the nature of the order.
Then what happened on the basis of this direction?
Nothing. They proceeded with the inquiry. They did not comply with this order, despite my representation at page 171.
Then why didn't you point out to the coordinate bench? Coordinate
No,
bench.
no, I will not say it. I will not say anything. I was not there. I cannot comment on that. Whatever was prudent on their lordship's part, I take it, that was the order.
Lost your chance, Mr.
Now, whether, the coordinate bench's order, please come back, if your lordship kindly takes the, I am telling your lordship what exactly. 387.
Court said that there is no independent finding.
Yes. The judge who has recorded the events, please see page 387 once. We are informed, what prompted their lordships, perhaps is this. that the pleadings are complete in all respect and the main matter is otherwise ready for final. We therefore do not intend to interfere with the impugned. However, it is open to the writ petitioner to take appropriate recourse before the tribunal in the form of clarification, and we hope and trust the tribunal would consider the same on merit. However, we feel that the matter being ready may be disposed of at the earliest, etc. Please
read the second paragraph of
Yes.
the order.
We are
By the impugned order, page 386.
my lord.
After
Yes.
recording the submissions directed
To exchange, which is now construed that such observation creates an impediment on the part of the disciplinary authority in proceeding therewith without redressing the grievance so raised by the writ petitioner. The ground on which the tribunal was approached pertains to alleged discrepancy in the disciplinary proceedings and the submission was advanced, appearing for the writ petitioner, highlighting the same, which unequivocally gives an impression to us that it was mere recording of submission at the behest of the parties and cannot be perceived to be an independent finding returned by the tribunal.
Which finding?
With respect, there was no finding.
No, the second paragraph says that the disciplinary authority was facing an impediment.
Yes.
It was the other stand, not your stand.
According to me, it was it is a wrong. I won't say because this order stands.
No, very good. Now, what did the ground on which tribunal pertains to and submission was advanced, highlighting which unequivocally gives an impression that it was a mere recording of submission. What was that submission, Mr. Bhattacharya?
Perhaps, please see page 194 once again, please. It's a challenge. Sure.
Sure.
Learned counsel for the applicant would point out some glaring defects in the proceedings initiated by charge sheet dated this, and the applicant has already filed reply to the charge memo alleging that the sum of the charges overlap that of the previous charge memo. IO is junior, etc. The bank account statements could not have been used as an evidence towards the charges. It is submitted that the IO has not yet fixed any date of inquiry. Therefore, disciplinary proceeding will look into.
এখানে কোর্ট বলছে যে pertains to a submission was advanced by counsel against
submitted that the IO has not fixed.
Has projected issue a speaking order.
Now, the speaking order apparently has never been issued. And Milan, I raised this point at page 175. Kindly cease.
So the coordinate bench was of the view that the second paragraph of the order was not a finding of the tribunal.
According to the Hon'ble Court. And I do not, for a person in service, all times, it is not possible to carry it, elsewhere.
Orderটা শুরু like therefore থেকে in accordance with law পর্যন্ত ট্রাইব্যুনালের অর্ডার।
ওটা তো ফেভারেই গেছে।
ফেভারে গেছে, yes.
এবার
why you have challenged this order? Tribunal's order is therefore the disciplinary authority will look into the grievances as projected in the reply to the charge sheet. Issue speaking order. If requires, IO shall be changed. You stated that IO was your junior. IO, that means EO, inquiry officer. And the respondent shall act in accordance with law.
So you created your own problems.
You have challenged this order.
Admittedly,
request the tribunal propose.
Now the position is, since the order was not interfered with, it presupposes the order remains.
Suppose what we decide to final to order ওর চ্যালেঞ্জটা তো অলরেডি ডিসাইডেড এগেইনস্ট হয়ে গেছে। ওরা প্রসিডিং এর ডিফেন্সটা কোথায়? তো কোনো ডিফেন্স নেই। এই জন্য ফাইনাল অর্ডার পাস করে করতে পারে, তাই না? Yes, when Mr. Ghosh, when you are concluding it, his anxiety is today, if the proceeding goes on, final order will pass his provisional pension.
The inquiry has already been concluded.
No, now the disciplinary authority will consider and pass the final order.
Well, kindly fix the time limit, so that by this time, kindly lordships kindly fix the time limit. By this time, we will dispose of the entire thing.
No, the thing is, what his contention is that don't conclude the proceeding. Suppose today you conclude the proceeding and suppose you pass a final order, that final order will be on the basis of unchallenged grounds in this writ petition, na?
He has.
Tomorrow, if you pass the final order, tomorrow, then this petition itself becomes infructuous because we cannot stop you that don't take these points. Tribunal has directed against him. So the points at page 194 that the charge sheet is overlapping, etc., or the junior inquiry officer was junior, etc. This attains finality. Na?
If you should kindly see the impugn order.
No, what we are suggesting is, on your instruction, we have to finish it off this writ petition. We will finish off the writ petition. Suppose today if the writ petition is dismissed, in that case there is no embargo. But if we allow you to conclude, then we cannot tell you conclude, but don't take these points into consideration. We
Here,
cannot say that.
may I submit one thing? Here, charge sheet was issued. He duly participated. He raised point. Now, my lord, we are proceeding with the inquiry. Inquiry has already been concluded.
Right.
He will be given the opportunity, my lord, to respond of the inquiry officer's report. Now, my lord, we will consider the disciplinary authority will consider his, my lord, comments or his reply, whatever may be the, my lord. Then the final order will be passed. And if it goes against him, he has the liberty to challenge that order in appeal.
Right.
Because there is no stay. We have already concluded. And now, if you kindly see the impugn order, everything has been stated. We have already changed the, my lord, inquiry officer. As per his, my lord.
The inquiry was over.
Yes, everything has already been over.
No. You changed the inquiry officer before completion of inquiry.
Yes, yes.
No.
Yes, well, kindly see the impugn order.
You took the point, since the person has retired, you cannot take the point of junior senior.
Well, if you should kindly see, my lord, the impugn order, my lord. Impugn order, my lord, kindly see.
Tribunal. No. If required. সেটা ও বলছে ট্রাইব্যুনালের অর্ডারে সেটা ট্রাইব্যুনালের যে সেটা তুমি পাবে পেজ 400 5.5 397.
At this stage, she having no any prejudice, my lord. Now it is settled law, my lord.
We are not saying we are with you,
my lord.
We are against you,
my lord.
But the thing is, suppose today you take the final.
At any point of time, my lord, he can, my lord. My lord.
Take the final decision. Final decision naturally, the order of the tribunal has rejected his claim that no overlapping, no junior, senior, all these points tribunal dealt with and passed an order in your favor.
My lord.
Suppose today, if you conclude the disciplinary proceeding, you will be relying on the same points, which is under adjudication for us. So your entire exercise will be frustrating.
My lord, here, what happened?
What we are suggesting is that we will keep the matter parented in fixed for hearing and dispose of the litigation. Then there is no bar on our party to see any party.
No, that I understand. Here today, my lord, lordships can because
that is why we are asking you that are you desirous of passing any final order till the reopening date?
My lord, that I have to take instructions because
please take instruction and come. In that case, we will not give him any interim protection.
My lord.
We will fix the matter and hear it out. Because today, if we uphold his ground, then what happens? The entire proceeding goes, no?
But that is,
Keeping that pending, if we allow you to proceed with the proceeding, final order they will bring by supplementary evidence. But your final order will be accepting the grounds of challenge which has been negated by. That is why we are asking.
my lord, he has not the, my lord, remediless. As to why I am telling your lordship knows, the disciplinary authority will pass the final order. Now, after that final order, my lord, he has the right to prefer appeal, challenging the same ground. There will be the fresh cause of action. There is no bar. There is no bar. I understand your lordship's view, but
Mr. Ghosh,
my lord,
today suppose you are the disciplinary order, you pass the final.
my lord,
In the final order, naturally, we relied upon documents which some allegation were that you did not give me or I did not get chance. Those matters have been finally decided. So naturally, at this stage, you cannot give him further documents. You will pass the final order.
well, your lordship may, my lord, direct the authority to keeping and to take all points open, and that has already been done by the earlier court. Earlier division bench has already given that liberty. Your lordship may pass that order, my lord.
Earlier division bench,
My lord, kindly see.
what liberty has been? What liberty?
Kindly see, my lord.
Coordinate bench
Yes, my lord, we therefore do not
clarification application.
open to the writ petitioner to take appropriate recourse before tribunal in the form of clarification, and we hope that trust the silence. So his challenge has already, my lord, failed. His challenge has already failed. Again and again, he is, my lord, agitating same thing. Now the final order has already been passed. And what wrong the tribunal has committed? Today he has no prejudice, no punishment, nothing has been issued against him. He may challenge in, my lord, several grounds.
You are not considering what we are saying. You
Well,
are not applying your mind on that.
my lord.
We are not passing any interim order in his
Well, then, my lord, as your lordship.
We are asking you.
My lord.
We are asking you that let us decide the matter. Because tomorrow it will be problematic for you.
Okay, very well, my lord. I'll.
If you pass the final order and if you strike down the order of the tribunal, what happens to your exercise? Tell us. It will be futile exercise.
Very well, my lord. As your lordship is, my lord. I will not be, my lord, standing in the way, my lord, your lordship. If your lordships do not pass an interim order, then I do not have any.
That is why we ask.
Very well, my lord.
We are closing down. We are fixing a date. But in that meantime, whether you are, because you will also take time.
My lord.
Disciplinary authority will consider the. If you
I have not yet.
Wait. If you tell us that no, suppose your lordships are keeping on 28 November. In that meantime, we will take your word.
That what, my lord, I cannot, because there are, my lord, lot of smaller departments. I will be difficulties. Because decision has to be taken by
Instructions.
decision has to be taken by, my lord, the Delhi.
As we know, my lord, subject to correction by your lordship, if there is a penalty, there cannot be any interim order on a penalty. Today, your lordship is looking at a position where I have questioned the departmental inquiry on various grounds, including, my lord, simultaneous proceedings. The issue is before your lordship's court. At a stage when, owing to, non-subsistence of any interim protection, I had to, under, whatever circumstances, give out my evidence, participate in the proceedings. Otherwise, it would have been construed to be an ex parte proceedings, and an ex parte inquiry would have not seen the light of the day. Today, kindly balance the equities. My lord, I will be requesting your lordship, my lord. I have been at page 217 called upon to give a response to the inquiry officer's finding. My lord, without prejudice to my rights and contentions to whatever I have filed already, your lordship will extend the time to file my response without prejudice to your.
Where is your response?
My lord, my response is a one-line response, supplementary affidavit.
Which is that page?
And that page is not on record. I have brought it, my lord. Lord, I have filed a supplementary affidavit. This is my response.
You have
Now, please see page 5 of the supplementary.
Have you given copy?
Yes, yes. Lord, this is in response to 217.
What is the problem?
Well, this is, well, I have to deal with.
You have reiterated your grounds of challenge.
Yes, but my lord, I have to deal with each and every issues, my lord, raised in the inquiry officer's report. My lord, that is, my lord, what are response to the chart.
You yourself for
Waived your right.
My lord, this is, my lord, with respect, my lord, it's a question of law.
We will decide states taken will avoid by you. Because your coordinate bench has refused the interim order. That in that particular we cannot.
My lord, may I just say this, subject to what falls from your lordship? If he can come back, my lord, next week or week after next. No, I am not saying, I am not asking him to preempt.
He will talk over phone. They will say, no, we will not do anything. Suppose an order is passed, he will not have any conflict.
The only difficulty is in the event an order is actually passed.
Come to us. Come to us.
Kindly clarifies that. Because my lord,
the occasion has
kindly visualize.
Born, you want us to eat.
My lord, the child might not have been born, my lord, but the child birth is in the offing. Any day it may be born. And in that event, my lord, who is going to celebrate the birthday? My lord, whether the cat or whether my lord? That is the question.
Leave it upon us whether we will taste, whether we will celebrate or we will.
No, let us, my lord, know. Celebration, my lord, may be either way. My lord, kindly gives me some balancing protection, my lord. Kindly strike a balance. Kindly find, my lord, find out some solution, my lord. I am in a sticky wicket, I am telling you, lordship. I am being very honest. Yes, yes. But in the meantime, my lord, if something. But in the meantime, also, my lord, kindly grants me to additionally give a response to 217.
Because your contention does not say so. Your contention, we were minded that you be afraid.
As your lordship pleases.
You have used any opposition to the main?
Yes, yes, yes. In the main matter, yes. No, wait.
the tribunal.
Yes, yes. Yes.
That has been annexed.
Yes.
You're sure?
You know, affidavit in reply and rejoinder to the reply. You know, page 254.
Then Mr. Ghosh, you need not file any further pleading.
No.
No, I leave it to his good office, you know, if he can do something.
It's said also.
Month থেকে কত টাকার পেনশন নিলি এইটুকু গো
Use the matter for release the matter for final hearing. Lady supplementary list of this court on 5th December. It is made clear that steps taken in the meantime by the respondents shall abide by the result of the petition. Yes, next.
And also, my lord, kindly record the lordship has not passed any interim order.
আবার এইসব কথা বলার মানে that means
Kindly, my lord, that way. Kindly record that, my lord. Because everything has already been completed, my lord. Now, my lord.
Completed illegal. Completed, yes.
That's the right, my lord.
Next matter.
Great.
My lordship is fixing the matter, my lord.
On 5th of December.
5th December.
You are not using any reply or.
No, nothing is required, my lord, because everything has already been.
As a one bonus, one bonus. Hardened part হলে ভালো। I might lose,
No, I don't have any difficulty. I
let
don't
it
have.
be hardened part.
Yes.
As you love.
Next.
Your Lordship, I was directed to submit the list of dates, Your Lordship. It একটু দেবেন।
Hearing matter. Yes,
Your Lordship, the petitioner was,
you have concluded your arguments. This
Yes,
is the
Your
matter
Lordship.
that
Respond-
RTR tribunal was approached.
yes, Your Lordship.
Uh-huh.
Yes, review was allowed in this honorable court. And the file of
এটা কি অন্য মামলা?
review was allowed, Your Lordship. On the previous day, this file was not available with the WPCT.
I see.
And one affidavit of,
So who filed the review?
I filed, Your Lordship, and it was allowed. I was the petitioner. My application was dismissed by the Honorable Division Bench in 2019. I preferred a review before the assigned bench. The review was allowed, and this.
Did we hear this matter?
Yes, Your Lordship. It was heard on 26th of this month, Your Lordship, last month.
Oh, no.
He was a selected semi-skilled tradesman of the.
Just a moment. Now what happened in the how many petitioners are here?
One only, because in the previous writ petition, Your Lordship, there were two petitioners, but after filing the memo of review, the second petitioner, the first petitioner not join, Your Lordship. He could not file the due to this COVID outbreak, and later on he left all his hopes and the proceeding as well, Your Lordship. Because
one writ petition was filed by Soumendra Banerjee.
No, Your Lordship.
Item number 8.
9, Your Lordship.
Oh,
This is
9.
9.
Sanjit Ghosh.
Yes, Your Lordship.
Sanjit Ghosh and Vikas Koda.
Yes, Your Lordship.
So two separate writ petitions were filed.
Both
of them were disposed of by common judgment. Against that, the review was preferred by one applicant.
Memo of appeal was filed for both of them, but one could not file the application, Your Lordship. The second, Vikas Koda. So order was passed in one.
But pertaining to the same judgment.
Yes, Your Lordship.
Both the writ petition were disposed of by common judgment.
Yes, Your Lordship.
Yes, tell us then what happened. Now, after the review has set aside that order.
Yes, Your Lordship. On two grounds. First, the respondents submitted before the Honorable Court that he appeared in the retest and he did not qualify. which was a wrong submission. Because even if he had appeared in the retest, result was never declared, and later on during the course of the hearing of review application, they disclosed that the entire selection procedure has been cancelled. Retest was also cancelled, which was never found in any website of the official website of the OF Damdam or anywhere else. Your
But
lordship.
what did they say in the affidavit?
They said that the process has been cancelled because we do not need any further manpower. That is.
No, but that was not the answer sought for by the tribunal.
Yes, your lordship. But and
To your
another
list of dates.
question.
Come to your list of dates.
Yes, your lordship.
On 11th of August 22, the division bench directed respondent to produce the result of retest and the proof of publication. Then
Yes,
what the affidavit was filed on 31st August?
Yes,
Where is
your
that
lordship.
affidavit?
Yes, your lordship.
Have you brought that on
Yes,
record?
Yes, your lord. It is in the review file of review application, your lordship. This is a copy is with me, your lordship. An undated letter was given, your lordship, by the joint general manager. That is at page 6 of the affidavit submitted by the respondents.
We find notes of argument. Affidavit.
Page 6 is the cancellation of direct recruitment 27 tradesmen. Copy to deven, ekটু দিয়ে দেন.
No, not required. You are saying it is annexed.
Yes. Reviewer file ta sir.
Page?
Page 6, your lordship.
When was the retest conducted according to
30th November 2014, your lordship.
when was the first test held?
It was on 2011, 7th of March, your lordship.
4 to 10 September 2010, my lord, that was
Advertised.
advertisement,
And
my
test was
lord.
conducted.
Then nobody has been given appointment.
No. No, your lordship. Attestation form was issued, but appointment letter was not given for more than 2 years.
That was pursuant to the test of 7th March 2011.
Yes, yes, your lordship.
In that you were not successful.
I was successful. I secured 3rd position, your lordship.
Then what was the requirement of the second test?
Because some irregularities were found with the officials.
Cancelled.
That was cancelled. In the wake of this application.
Challenging that cancellation, you came to the
Yes, your lordship.
tribunal. Now, during pendency, they conducted a retest.
No, during the pendency of the original application before the Honorable Tribunal, they conducted the test.
Very good. That is what you are saying.
Yes, your
Now,
lordship.
what did the tribunal say?
Tribunal directed me to appear in the retest without prejudice to the outcome of the application.
I see.
I had objected
Now you participated.
I participated, your lordship, and on this ground, my one post was kept vacant. I was given status quo, but while deciding the entire application on merit, this was a ground that I appeared
Now
in the
you are working
retest.
in which post? You are not in service. You are applied for tradesman.
Yes, your lordship. And I was selected by another ordnance factory of the same board in the same year, your lordship. And unfortunately, I did not join. Of this, and this 145 post was also including this 27 tradesmen because 36 reserved vacancies were there, your lordship. And I was not issued admit card, your lordship.
How can we help you, madam?
Your lordship, I was given.
The very selection, the entire recruitment process has been done away with. It is not a case that they have given appointment to a few and left out others.
Yes, your lordship. But they have conducted the retest.
Yes.
They did not declare the results. They did not declare the reason for not declaring the results. They did not cancel.
It is the prerogative of the employer.
No,
That
your
why
lordship.
will we conduct or will we not?
No, on this ground, my case was dismissed because I participated and they submitted before the honorable tribunal that a result will be declared soon. Result will be for 4 years. They did not declare the results. And when I came before the honorable court for review, and on the ground that I was not given the admit card for appearing in the examination of 145 of the subsequent selection process, your lordship, my candidature was not accepted without any reason. And for that reason, they were twice or thrice they were issued summons by the court, your lordship, by the honorable court. Until 2000.
To show us an authority that this becomes a case of compensation. We are worried about you. You have been not handled properly. But today they have taken a decision that we will not proceed with that selection process.
Your lordship, this is about the reserved category. The entire 27 posts were for reserved candidates. The government directives are there that they cannot withhold the appointment of.
That is not the subject matter of the dispute. You have, it is not a case that you have challenged the memo of cancellation of the selection process.
Memo was not issued, your lordship.
Right, whatever it may be. But today, suppose we decide in your favor, then what benefit we will give it to you? Can we say that appoint him to the post of tradesman? They will come and say that we have done away with the selection process. We cannot help you.
No, your lordship, 138 posts have been till date appointments to 138 posts are given. Rest of the posts are lying vacant, your lordship. And one post was kept vacant throughout the 9 years, your lordship. For this person, because he has been deprived thrice, not on 1, 2 or 3. Your lordship, the orders, I may be allowed to refer the orders, your lordship.
We will go through the orders. We have put you a question. You approached the tribunal that you conducted the selection process, but I was selected, but you have not given me appointment. This was your grievance.
Yes, your lordship.
So when the tribunal was hearing this matter, they came and said that no, that has gone. We are conducting a retest.
Yes.
Then the tribunal said, all right, you will appear in the retest and one post will be kept vacant for you.
No,
right?
My post was kept vacant from the first hearing, your
Very
lordship.
good, very good.
Because
now the tribunal dismissed your original application.
Yes, on the ground that I appeared in the retest.
Right.
But
on the ground you appeared in the retest. Challenging that, you came up before us. Your writ petition was dismissed. We have not seen the order yet.
Yes, but
you went up in review.
Yes, your lordship.
Review court said that there has been no declaration of retest results. As such, the order passed by the court is set aside, reviewed. Now we are hearing it afresh.
Yes, your lordship. In review,
you satisfy us one point.
Yes, your lordship.
That the employer cannot take such a decision. Show us a judgment and authority that the employer does not have the prerogative to keep us in abeyance and cancel a process 4 years after the initiation of the process. Show us an authority on that.
Yes, your lordship. One rule I am having, your lordship, which says they have to re-advertise.
Not rule, you come with a judgment.
Decision, your lordship. Cancellation, I have referred a number of judgments which are given in the final order of the tribunal.
You show us a judgment. Because starting from Kalimuddin's case, it had been reiterated by the Supreme Court that selection process, whether post will be created, will be filled up, whether this is absolutely the prerogative of the
yes, your lordship.
Even if you are in the panel.
Yes, your
that
lordship.
does not give you any
right. Yes, your lordship.
I am on that point.
Today I am not having that judgment, but your lordship, facts are something different.
Come
here.
with the judgment. Come with the judgment.
Your lordship.
To satisfy us that even if it has been done we can give you the benefit.
Your lordship, just because they did not declare the result of retest and they submitted before the
We
honorable
are with you.
division bench.
We are in your favor. We are with you. Your argument is a right has accrued in my favor. You cannot deny me that right. It is your contention.
Yes, because I have been deprived thrice, your
We
lordship.
understand. You show us an authority that due to such accrued right, court can direct them to appoint you to a post in respect of which the selection process itself has been cancelled.
Your lordship, on the earlier date, your lordship had directed the respondent to show the cancellation, order
Yes,
of
that is
cancellation.
in
Yes,
page
but
6.
this is undated, your lordship, and the
Not
manner.
undated.
Yes,
We will proceed on that
Dated
basis.
12th
Yes,
January
your lordship.
2020.
And the entire
You please
procedure.
apply your mind on this.
Yes, your lordship.
What is your right which you are insisting upon, and whether we can give you that benefit
Yes, your-
irrespective of the fact they have cancelled.
Yes, your lordship.
Because the cancellation is not the subject matter.
Yes, your lordship.
Today, if we send you back to the tribunal, it will again take 10 more years to decide that one.
Yes, your
We will
lordship.
decide. You show us that authority.
Yes, your lordship.
Mm.
If I had been given an opportunity to appear in the subsequent selection process, your lordship. So
Yes,
it could
because
have been a
what
different.
is the issue? Are you filling up the posts in the near future?
No, my lord, because that now Yantra India Limited has taken up.
Huh?
Yantra India, YANTRA, Yantra India Limited, they have taken up all the defense related factories, my lord. That includes 7 factories, including ordnance factory Dum Dum. And after it had fallen from your lordships on the last occasion, I inquired from them, though if your lordships direct me, I will put on affidavit, my lord, that they are not inclined to take, they do not need further manpower. And my lord, as regards, kindly allow
Why
me.
did you keep them in the lodge for 6 years?
My lord, I will. My lord, that was done, my lord, I admit.
If that was done, what is the benefit?
And my lord, kindly allow me another to file affidavit to this respect, my lord. I do not want that it comes from the bar. And another aspect, my lord, with 145 posts, my lord, my learned friend is referring to, my lord, that was entirely a different selection process. Be that as it may, my lord, I want to place before your lordship, my lord, that they had placed in the review application in the a counterfoil of the admit card, my lord, they are saying, means application for admit card, they are saying, and that they are alleging that we had not given them any admit card, my lord. So it took us some time, my lord, to find out why admit card was not given to them. I also beg to bring that on record, my lord. Kindly direct me to file an affidavit in that respect.
Why that direction must have been there earlier?
Yes, your lordship.
My lord, that because my
Several
lord,
directions have been
that was over, my lord, because that is also required, my lord. 145, as regards this 145, my lord, 145 posts, my lord, they had said that we have not given them any admit card, my lord. So kindly let me be given a chance to place before your lordships.
You are
My lord?
What is the requirement now? You have cancelled the process.
No, 145 was not cancelled. 145 appointments were given against 145. It was my learned friend's submission before the honorable court that they have not, we have not given them admit card, despite the fact that they had they had given a, they had applied for the same. But
your lordship,
I want to bring to your lordship's kind notice, my lord. What is the fate of that admit card?
Your
It should be
lordship,
for hard interest only, it should be brought on record.
lordship, on this ground, they have delayed the review hearing for more than 1 year, your lordship. Because they always file some affidavit, they make some other
I will take 1 week
submissions.
time, my lord.
Your
I will place
lordship,
before your lordship what
on-
is that,
before the honorable-
because it is not at all related to Dum Dum Ordnance Factory. I will bring it on record. I want to bring it on record. Kindly, I beg of your lordships.
To bring the records.
Yes.
My lord, kindly pass a direction, my lord, to that effect. My lord, otherwise, my lord,
First they
kindly allow me to
submitted-
submit an affidavit, file an
Your lordship,
affidavit.
first they submitted.
You cannot act as per your whims.
Yes.
You ask persons come, we are filling up the post. You are a model employer.
My
You
lord, I
cannot act
I
as-
bow down, my lord. It was not related to that, my lord. I am praying for accommodation with respect to 145 posts, my lord. Because they have said repeatedly, they are arguing that it is their contention is that they had made application for the post of this tradesman post, semi-skilled tradesman post in ordnance factory, and we have not issued any admit card to them. I want to bring it on record, my lord, whether it is that relating to that application or whether it's relating
on this ground,
or whether it's relating to that another application relating to Nagpur, my lord.
Your lordship, on this ground itself, the review application was allowed because they have misrepresented.
That was not
the
taken on
honorable-
record.
Heard.
Yes, your
You
lordship.
have heard what you are repeating.
I tried to, my lord, place on my lord.
You
My lord.
bring the records, whichever record you are relying upon, we will look in.
If your
This
lordship
is our-
kindly pass a one-line
Not
order.
a
my
matter
lord.
of kindness. It is a matter of the procedure. Writ petition was disposed of. Review, order set aside. In
My
the
lord.
writ petition, whatever materials are there and the records which you are producing, we will look into the records.
So I may be allowed to file on affidavit, my lord, because after that, after the review hearing was over, my lord, it took some time for us.
It's appearing for the respective parties. This is the matter for final hearing. There is supplementary list of this court on 11th December. Yes.
11 December. My lord.
এই review
Review,
file-
right, my
এই যন্ত্রের সাথে review fileটা on 11th you produce whatever records you
My lord, I will deeply oblige, my lord.
কি একসাথে অর্ডার হয়েছিল আগের দিন আচ্ছা রিভিউটা এই অর্ডারটা what were the এটা WPCT 2 আর WPCT 1 একসাথে অর্ডার করি in the other also you are appearing.
Yes, my lord. But that is a review করেছে, ওটাতে তো
No,
review.
not the review, the original.
Yes, yes. I appeared in both the matters.
Yes.
Order to একসাথে হ্যাঁ? তারপরে তো রিভিউ হয়েছে রিভিউতে হ্যাঁ কোথায় দেখো both WPCT was disposed of. Both the writ petitions were disposed of by
Yes.
common judgment.
Yes, your lordship.
You sure?
Yes.
Judgment
your
was
lordship.
passed, my lord. Main judgment was passed, my lord, in Bikash Kora versus Union of India.
Very good,
WPCT
we can
possibly
take-
won, right?
But it was connected.
But it was, and
Referred.
that was in this matter, my lord. It was recorded by their lordships that that matter will, the judgment passed in Bikash Kora will apply.
Yes,
my
yes,
lord.
your lordship.
দুটো একসাথে করো
Deeply
Deeply
obliged.
obliged, my lord.
you come with your judgments.
Yes. Yes.
Yes.
Right, please, Your Lordship.
Your Lordship, I appear for the respondent. I want a week's time in this matter because Mr. Bhomik, who was appearing in this matter, his father has passed away prior to 3 to 4 days back. A week time is necessary in this matter, Your Lordship.
Tuesday week করে দাও
As Your Lordship.
yes next
Next one.
Please, your lordship.
that
Lordship, this is that matter whether
where
the
is your other
tribunal.
side?
Lordship, in this matter, Mr. Photik Chandra Das is appearing on behalf of the respondent, Lordship.
Hmm.
Lordship, the petitioner communicate one letter to the learned advocate to withdraw the matter before the Central Administrative Tribunal, Lordship.
Lordship, if that be so, then Lordship, but this was a point of law which needs to be decided.
That
Lordship will
will-
kindly make an observation,
we will decide in a better matter, Misa.
because after all this, after all these days, Lordship, let them, because otherwise what happens is Lordship, this is likely to go on. It's a point of law which needs to be addressed.
Yes,
That is
give
why.
us the written instruction.
Yes, let it be there, but I mean, I have a
So
few.
it goes in your, because
He has withdrawn, but let Lordship will kindly make an observation because that, I mean, Lordship, I have even got a 5-judge bench decision of the Honorable Apex Court that, I mean, a jurisdictional fact, Lordship, I mean, one cannot assume jurisdiction, Lordship. There are 2 decisions of one of the High Court and one of the Supreme Court that I would like to rely upon, and a number of decisions on Section 14(2) of the Administrative Tribunals Act.
the tribunal passed an order in their favor.
Yes, but
Final
Lordship,
relief. Final relief was granted.
no. The issue was relating to the jurisdiction of the tribunal, whether an employee of the Raja Ram Mohan Rai Library Foundation
Yes.
could be, whether the jurisdiction of the tribunal could be extended to him or not.
So tribunal held that tribunal had
the jurisdiction.
Now,
Lordship, that is why we had.
Now the original application, the issue of on grounds instance disposed of, the matter was listed before the tribunal. Now,
We came.
against that you came up before us and said that High Court has the determination.
We
not
have,
the tribunal.
that is, yes, Lordship.
So we will decide it in a better matter, Ms. Malam.
Lordship, but then, but actually what happens is a matter.
We will not be getting.
Then Lordship will kindly say that because it has been withdrawn, I mean, because let it not be the impression be carried that we went to the High Court and nothing happened, Lordship. That is what I want. Because this is purely on a point of law, whether the employee of the RRLF, whether the tribunal has jurisdiction or not. I mean, this is actually, Lordship, this becomes a, I mean, judgment in rem, Lordship.
Don't in the tribunal.
Not yet, Lordship.
Not yet. Then if we get something
Lordship,
here and then Lordship,
crime
that
check
is.
not directly written to the advocate, Lordship. This is to the department, Lordship, and copy to learned advocate, Lordship.
Because I don't have any instructions to that effect that he has withdrawn. Therefore, this can be misused, Lordship. Therefore, Lordships will kindly.
Then you withdraw the come with a proper instruction.
Lordship, what happened, Lordship? Client didn't written us the letter to withdraw the letter. He has only communicated this to us.
The authority.
Lordship.
But you are the council, you have to come and tell us that you will not proceed with the original.
He didn't
you need a communication from.
Then there will be some confusion later on.
The Lordship,
If
kindly,
we act on the
adjourn
basis,
for 1 week, Lordship.
because this has been going on, Lordship, what is happening is, Lordship, Lordship, a very calculated dilatory tactics has been going on, Lordship. There was a.
Has withdrawn. Should have not dismissed. To be dismissed as withdrawn. Maintain it is a point of relationship, point of
If unconsidered, decided in an. So you ask your client to this is not a proper communication.
Lordship.
You come with a proper communication, take appropriate, because if the matter is dismissed as withdrawn, the point of limitation will merge, point of maintainability merges with the order of dismissal as withdrawn. There is no decision on.
Yes,
and Lordship, this matter
So,
requires a
that
decision.
yes, she may still insist. That is our discretion. We will do it, but she can legally make a prayer that as the point of maintainability has not been decided, you decide the issue, so that there will be other matters also.
Yes, Lordship. That is my prayer. Lordship
Party
will,
Salam,
Lordship will kindly give a very short date. This has been,
after vacation. Salam.
Lordship, it's been going on for a long
That
time, and
advocate
little frivolous grounds the respondent has taken.
we can
This
this point will remain, Miss Alam, in a separate case. We will defer our endeavor in a better case in future. What is
His
the
Lordship,
use of hearing?
these things are used to misguide the court, Lordship. The High Court did not pass any order. I mean, these things are very, I mean, this is sufficient to misguide the court, the tribunal in future. That is my only apprehension. His Lordship, my prayer is the question of maintainability. Your Lordships will kindly decide.
For an application to avail necessary instruction. List this matter in list the matter for further consideration in the daily supplementary status. 7th December. We are keeping it on 7th. You take appropriate steps before the tribunal, then we will consider.
But it has to be decided, Lordship. That is my prayer.
Pardon, Mr.
I mean, the matter should be decided because the it needs a judgment is required in these matters, Lordship, because the way it has been dealt with. I mean, that is my prayer, Lordship. After
There has been a judgment against you.
no, there is all Lordship.
I gave you 2 citations. I will give you
No,
another.
but then Lordship, I I have found judgments where, I mean,
Please do the needful so that we can decide. Yes, next.
I'm appearing on behalf of the petitioner.
Yes.
Your Lordship, on the last occasion, Your Lordship has directed us to prepare a list of dates. Your Lordship, we have prepared it. We are handing it over, Your Lordship.
Yes. Yes, tell us. A list of dates. Yes.
Your Lordship, the matter was regarding employment of Dark Sevak, Your Lordship, who had misconducted, Your Lordship, by defrauding Your Lordship, people, Your Lordship.
Place the judgment impugned first.
Yes, Your Lordship.
Is it a longish judgment?
Yes, Your Lordship. Your Lordship, in this judgment, Your Lordship, the matter was remanded back, Your Lordship, on the ground that the punishment was too much.
Disproportionate.
Yes, Your Lordship.
Acha, you place the judgment. Come to page 150. Yes. You can place it from page 151.
Yes, Your Lordship. Your Lordship, from
150 was the Xerox copy. You have got it?
yes, Your Lordship. Your
Yes.
Lordship, the beginning was, Your Lordship,
The order, the disciplinary authority ordered, the appellate authority
all
ordered,
was in
all were set
All was
aside.
enough.
After that, they have come to the tribe.
Your Lordship, no, Your Lordship, in all the matters, Your Lordship, the punishment was upheld, Your Lordship, and then they preferred this
That is
application
what we are saying.
Yes,
The
Your Lordship.
statutory appeal was rejected.
on the ground that, Your Lordship, in one of the matter, Your Lordship, the criminal trial court has acquitted the petitioner, the respondent, Your Lordship.
Facts will be here, no?
Yes, Your
Please place it. We will.
Your Lordship, this application has been preferred to seek the following relief, Your Lordship.
You can come to paragraph Next page, second paragraph.
Yes, Your Lordship. The
Facts.
facts of the case, Your Lordship. The applicant Shimanto Kumar De, while working as CD SBPM Banchi Chandipur BO in account with Jilia SO under Bishnupur subdivision of Bankura district, a surprise visit was conducted by Inspector of Post Bishnupur subdivision on 25/4/2012 to inquire into the complaint lodged by one villager against Sri Shimanto Kumar De. That's the respondent, Your Lordship. Upon verification of records, the following position got involved, Your Lordship. These are the defraud details, Your Lordship. Said Sri De committed fraud by making false withdrawal voucher from the RD account number 86613 on 28/3/2011, forging the signature of the depositor, Shubal Digor, who expired on 30/7/2004 and used LTI during transaction. Your Lordship, the amount was 2197. The second fraud was by making false withdrawal voucher from the SB account number 841178 on 18/4/2012, forging the signature of depositor Anando Konar. This is of 5,000 rupees, Your Lordship. And the third one was by making false withdrawal voucher from SB account number 838727 on 10/1/2012, forging the signature of the depositor Madan Mohan Jana. That's 2,300, Your Lordship. This third one, Your Lordship, the third fraud, Your Lordship, in this there was a criminal proceedings, Your Lordship, in which
There was an equivalent.
yes, Your Lordship.
Yes, continue.
Then, Your Lordship, the respondent deposited the amounts, Your Lordship.
What is this UCR? UCR dated 26th April.
Your Lordship,
Anyway.
Unclassified receipt.
Huh?
Unclassified receipts.
Unclassified receipt.
then he was charge sheeted under Rule 10 of the GTS, Conduct Engagement Rules 2011. Vide, Senior Superintendent of Police Offices, Post Offices, Bakura Division, memo dated 26/11/2013, alleging violation of departmental rules and procedures. An FIR was also lodged on 10/12/2013, indexed as PS case number 121/13 under section 134 of the Code of Criminal Procedure, based on General Diary number 386 at Jaipur Police Station, Bankura. The said Shimanto Kumar De moved OA number 1447 of 2013 against put of duty order before this tribunal, which was dismissed on 8/7/2014, and further assailed before the Honorable High Court in WPCT number 134 of 2014, which also got dismissed by an order dated 14/8/2014. He again moved OA number 1616 of 2014 before this tribunal, which by an order dated 16/12/2014 directed the disciplinary authority to consider his representations dated 11/8/2014.
So how he did that? Prior litigation was decided against him. Put of duty order was challenged.
Then, Your Lordship,
Yes,
he was not successful. He made several
Then
applications.
what was the subject matter of the second original application?
Your Lordship, the
OA 1616.
Your Lordship,
Anyway, you
Instead of he
continue.
go-
You continue. Your list of dates.
list of dates, Your Lordship.
List of dates টা কোথায় রাখো? আজকে এখানে আছে। আচ্ছা, first, madam, you finish it off.
Yes,
Then
Your
we
Lordship. As Your Lordship.
acha, dispose of by reasoner, in compliance, reasoned order 29th January 2015, no barring simultaneous action. Citizen move tribunal. Appellate of appeal was
Then, your lordship,
such and such. You please give us 2 minutes. We shall go through the order. You need not
yes,
proceed
your
to
lordship,
argue.
yes.
Yes. Or we come back after. We are coming. You please keep those pages. The final order which was passed by the authority, the initial complaint of the villager, if you have that.
Initial complaint of the
Please take
villager,
up.
your lordship, in respect of which the criminal, no, your
No,
lordship.
not the criminal, yes.
The other one,
Charge sheet was, inspection was held.
inspection was
On
held, your
which
lordship.
instruction it was held. First paragraph of the second page.
No.
খোলো খোলো।
We are of the considered opinion that there is nothing wrong with the approach and decision of the learned single judge. No arbitrariness, malafide, irrationality, or perversity would be established by the appellant. Accordingly, the appeals and the connected application are dismissed.
My lord, may I take inspection of this?
Get it in the server today. Hey, it is server. Yes,
Oh,
call the
my lord, my lord, humble prayer, my lord. May it be stayed, my lord, because there is a ensuing puja, my lord, my lord. I oppose this prayer, your lord.
Yes, next.
Your lordship, so far as that one villager,
Which are your matters, that group of matters? 21 to 23.
Along with item number 246 of the monthly list.
Your other side is here. No, he is for the, who is for the, these are for the
Admission.
leave to appeal.
Yes, leave to appeal.
Where is the, who is appearing for the applicants?
One.
20 is the other.
and 24.
20.
22, 23.
And who is in the other matter?
Shankar Bhattacharya is there.
So we are in the midst of hearing.
Yes,
Call the other person so that we can dispose it of and fix it with the other.
Shandal was also appearing for one of the matters.
Pardon?
So Shandal was appearing.
You call, you give, you said, so you come back to us at 3 o'clock and remind.
I shall.
Because this matter will take some time.
I shall.
Yes, yes, madam.
your lordship wanted to know about what was the complaint lodged by one villager that is mentioned here, your lordship. Your lordship, this refers to the complaint made by Madan Mohan Jaina, your lordship, in respect of which the criminal proceedings.
Yes, that
continue.
was Madan Mohan.
Yes,
Now,
your
kindly
lordship.
come
We
to the-
don't have the
Srikanto
letter.
They, while working, a surprise visit was conducted by the inspector to
Yes,
inquire into
because-
a complaint lodged by
Yes,
one
your lordship.
villager. Who is that villager?
Your Lordship, that is Madan Mohan Jena.
Oh, that villager is Madan Mohan?
Yes, Your Lordship, in respect of which the criminal proceedings took place. Your
Madan
Lordship.
Mohan Jana
Since
is
it-
having an account against Article 3 of the charge, Madan Mohan Jana.
Understood the question.
Your
Yes,
Lordship-
now you argue what is your argument?
Your Lordship, my argument is that Your Lordship, all the orders Your Lordship will go through, Your Lordship, it has been passed, going through the documents, evidences, everything, Your Lordship. They have, and there has been no violation of natural justice or the proceedings that was conducted is in accordance with law. They cannot allege that it was not in accordance to the rules and regulations, Your Lordship. And no allegations of such has been made also, Your Lordship. So far as Your Lordship, violation of natural justice, that cannot be also made by them, Your Lordship, because all along, Your Lordship, they were given chance to represent their case. And not only that, Your Lordship, they had sought innumerous applications to delay the proceedings, Your Lordship. We have accommodated them. Means him, Your Lordship, the respondent, Your Lordship. So, Your Lordship, so far as this judicial review is concerned, Your Lordship cannot go through all the
We cannot
documents.
reappreciate.
Yes, Your Lordship. That's my first point, Your Lordship. And so far as the punishment is concerned, Your Lordship, I had shown on the last occasion, Your Lordship, it's not very tough punishment as they have said, Your Lordship.
Do you have any higher punishment?
This is the lowest, Your Lordship, because they can apply again for this job, Your Lordship.
No, we are asking, is there any higher punishment than
Yes,
dismissal?
Your Lordship.
Higher punishment than dismissal? What? You hang him up or what?
Dismissal from employment, which shall ordinarily be disqualification for future employment. We have not given that, Your Lordship.
Yes, place the rules. Give the rules.
Your Lordship, it's the nature of penalties, Your Lordship.
What you are reading?
Nature of penalties, Your Lordship.
Which rules?
It's the GDS conduct and employment rules, Your Lordship.
Yes. Give us
Your
a
Lordship,
copy.
on the last occasion, we had given the copy.
You have given a copy?
Yes, on the last occasion we had. আর আছে?
এইখানে খুঁজে দাও না কি আছে? Give one copy.
That I don't remember, Your Lordship.
Acha, what you are placing from here?
Your Lordship, the nature of penalties, Your Lordship. The penalties that could, it's section 9, Your Lordship. Rule 9, Your Lordship.
Rule 9.
9. Nature of penalties.
Rule 9.
Yes, Your
7,
Lordship.
8.
Nature of penalties.
Yes, what you are saying?
Your Lordship, the penalties that has been stated, Your Lordship, one is
What
censure.
punishment have you given?
We have given removal from employment.
Page, where is that punishment?
That is 9(5), Your Lordship. The
Page?
punishment order.
95.
No, Your Lordship, it's rule 9(5), the punishment that we
No,
have.
we want to see your penalty.
Yes, Your Lordship.
Order
Your
of
Lordship,
punishment,
kindly
the
just-
operative portion of the order of.
Yes, Your Lordship, I'm just,
No, আজকে দুটো দিয়েছে। Appellate authority order is at page 94.
82.
82. To exercise rule 5. What is rule 5?
That's at 82. Your lordship,
The rule 5 of GDS conduct and engagement rules.
your lordship, page,
That's it.
order statute.
What you're showing us, madam, this is,
Your lordship,
where is the Department of Post?
your lordship, it's at
Dark
page
ground
82,
conduct
your lordship. The order of
and-
punishment.
You have exercise power under rule 5.
Yes, your lordship. Removal from engagement, your lordship, which
Done.
allows him to again apply, your lordship.
No, rule 5 is termination on medical grounds.
Rule 9.
Rule 9, your lordship,
Have
9(5).
you seen page 82?
Your lordship, it's nature of penalties, your lordship, it's 9(5).
Please come to page 82 of the writ petition.
82, page 82.
It is rule 5 of 9, your lordship.
Rule 5 of 9.
It's actually 9(5).
Where do you get rule 9?
That's not given, but it's written, your lordship, removal from engagement, your lordship.
Of rule 5 of rule
Yes,
9.
9.
You are saying rule 5 of GDS conduct.
No, your lordship, that is wrong. Rule 9(5). 9 in bracket, it should be 5, your lordship.
It's a punishment. How much did he refund? Entire money?
Entire money.
9,000 something.
Something. Your lordship,
dismissal from data CBI. Yes. So according to you, that was not the severe most punishment. Yes. Anything else you want to show us?
your lordship, a similar case was reported, your lordship, in SCC 2022.
Volume 7.
Your lordship.
Yes. No, show us how did you prove the charge? How did you prove
Your
the charge?
lordship, all the orders, your lordship.
No, the charge sheet.
Yes, your lordship. All the orders enumerates, your lordship.
Where is it, the charge sheet?
51. Article.
Page 51.
What was the list of documents you relied upon?
Your lordship, the list is
Yes, list of
page 60, your lordship.
page
60.
Page 50 is the charge.
60.
What is that?
Your lordship, paragraph 6, your lordship.
Page 60.
These are all the documents, your lordship.
No, that you will get at page, that you will get at page 54 also.
This inquiry report,
You have relied upon.
That's the inquiry.
Such it is.
That's the charge sheet, Your Lordship.
Kindly come to page 54.
Yes, Your Lordship.
Clause 5, written statement of Srimanto De, that is the petitioner. Written statement of Somir Roy. What is that? Srimanto Kumar De is the petitioner, na?
Srimanto Kumar De is the petitioner, Your Lordship.
So your list of witnesses were Harurani, Somir, Anando, Madan, and Sanjay.
Somir Roy was, is the officer, some of the, he was holding an official post, Your Lordship.
He
Then-
deposed. Did he depose?
Your Lordship, no, Your Lordship, I don't think so, Your Lordship, because he was transferred and he didn't appear.
Then who are the persons who deposed?
Your Lordship, Your Lordship will come to page 60, Your Lordship.
Hmm?
From there, it starts, Your Lordship. Your Lordship will kindly come to paragraph 7, the opportunities given to the charged officer, evidence on behalf of charged officer,
Hmm.
arguments, Your Lordship. And then, Your Lordship, documents adduced by us. That's a petitioner, Your Lordship. That's at page 62, Your Lordship.
Which para you are finding?
Your Lordship, from paragraph 9 onwards, Your Lordship. The reasonings and the documents that have been relied upon has been stated for coming to the conclusion. Your Lordship, like regarding Subal Digar, Your Lordship, it's at the end of page 62. Then regarding charges of Anando Kumar, it's at end of page 63. And middle of page 64, it's regarding MM Jana.
Page 70.
and no oral evidence.
Page 75.
Yes, Your Lordship, there was oral evidence.
Page 70. Page 71 থেকে actually. 7 September.
Because you see, after all the things, Your Lordship, it's written the above arguments have been tested by both oral and documentary evidence and corroborated by examination and cross-examination. Hence, it is accepted.
So where is the inquiry report? Inquiry report.
Inquiry report.
Hmm.
Your Lordship, inquiry report is this one, Your Lordship. This is the inquiry.
Page 59.
59 is the inquiry report.
So what is this page 71?
Punishment order.
Your Lordship,
70.
after the inquiry report was passed, Your Lordship, the respondent was given an opportunity to explain his cases, Your Lordship. Your Lordship will see it from the list of dates,
How
Your
can
Lordship.
it be the inquiry report?
Report
Page 71.
Page 71 is the
Punishment order.
punishment order, Your Lordship.
Page 71 is the punishment.
Punishment order.
Then where is inquiry report starts from page 59.
59.
Yes, Your
What
Lordship.
is the date of the inquiry report?
It's 19/7/2018.
Where did you get it? In the punishment order, first paragraph, page 71. Proposed to hold inquiry now under Rule 10.
Yes.
Where is Rule 10? It's a proposed inquiry under Rule. What is Rule 10? You have not given the total rules.
No, Your Lordship.
What is Rule 10? Yes, Mr. Sarkar, what is Rule 10?
Rule 10 is, my lord,
If you don't
it's
get
not
yourself
having-
ready, how many times we will write this memo such and such annexing Rule 10? Article statement of this is, how do you say that page 71 is the inquiry report? Is the disciplinary? So, yes, anything else you want to point out?
Your Lordship, a similar case, Your Lordship, was reported.
Yes. Yeah, this is 2022.
Yes,
2022.
volume 7.
22 volume 7.
22 volume 7.
Yes.
Page 475.
Page
475. The relevant paragraphs is page 14 and para 14 and para 17. Your Lordship.
did he deposited the amount prior to charge sheet?
After the order of put off. After the order of put off.
Before
Where is
charge
the
sheet.
put of duty order?
Your Lordship, page 13 of affidavit in reply.
আমাদের কোথায় ফ্ল সেটা বলবে, হ্যাঁ ফ্লটা হয়েছে it was on 25th April and he deposited from
26th.
all right. Anything else you want to point out?
Your Lordship, only that, Your Lordship, in
No, what
respect
is
of.
your argument as regards penalty? You can debar him because rule 9, if you come, there are 6 punishments. What the tribunal wanted to say was, do not remove him, you consider for some other suitable punishment. Court has not reinstated him. Court has not reinstated.
Yes, Your Lordship. Your Lordship, on the last occasion, Your Lordship had asked them, Your Lordship, what better punishment you think you could have got, Your Lordship. They couldn't reply, Your
Yes,
Lordship.
Mr. Sir. What do you are?
This is a post GDS BPM, Gramin Dak Sevak Branch Postmaster. This is a appointment in 18 age, at the age of 18, and till 65 they can perform.
Your client was appointed to the post of
GDS BPM.
GDSBPM.
It's a
What
Gramin
does the
Gramin Dak Sevak Branch Postmaster. This appointment, my lord,
yes,
appointment time 18 years and retirement in 65. There is no pension.
yeah, just
And my lord, in this particular case, 2 ways the respondents took up their cases.
no, what was that you said? He has a tenure from 18 years
To 65 years without granting any pensionary benefits and others.
no pension,
No pension, no pensionary benefit, only one,
gratuity, get gratuity,
no gratuity.
must be there.
Without gratuity is only 42,000 and odd. If a person retired, he will get 42,000 and odd. This is a new rule. In old rule, it is about 88,000 and odd. My lord,
From you are making this submission.
yes, ma'am.
Show us documents to that effect.
Rule 60, my lord, the appointment age in the method of recruitment is there.
Page
Method of recruitment, I perhaps these enough. In GDS rules, there is a proceedings called method of recruitment. It is 18 years to 25 years, 18 years to 65 years.
show us.
Method of recruitment is there. With any.
He has produced relevant extract in true sense. Only 3 pages.
3 pages. Okay, it
It
needs.
was your duty to
There
bring
also, my lord, I am sorry, my lord.
yes, what is your submission?
My lord, a criminal case was instituted. The person who has inspector, he made a complaint before the police station. FIR was lodged.
3 articles of charge in the DA proceedings, 3 charges in criminal case also.
In
In
criminal case also 3 charges?
3 charges.
Where do we find?
My lord. 1 charge,
One charge, that is the 3rd charge.
3rd charge, and
Madan
that has
Mohan-
not been proved.
Madan
my lord,
Mohan not proved.
Not proved. And my lord, in GM Tank's case, your lordship knows, in Gujarat, GM Tank versus Gujarat, my lord, I have annexed the judgment in my written notes of argument. My lord, shall I hand it over written notes of argument?
Where is? You
No.
did not file any written note?
No, I am prepared. my lord.
No directions? Yes, no.
The judgment is with this. দুটো copy. আরেকটা copy. আচ্ছা। My lord, in page 23.
So GM Tank will apply maybe in respect of the 3rd charge.
3rd charge.
At best.
And my lord, 1st and 2nd charge, there was no case.
Why?
My lord, in the DA proceedings, 1st charge, 2nd charge, my lord, they have at this best, they have said it is proved, but proved, merely saying prove will not suffice, my lord.
Why?
Your
The
lordship,
widow deposed. The widow
Widow-
of Digor deposed.
Digor died, and one lady came with the passbook, said, I am Digor.
I am Harurani Digor.
Digor, that is also not proved.
What is not proved?
Digor was not proved because in the
He
proceeding-
was the account holder, 86613.
So
Come to the annexure, page 54.
my lord, Digor is not a, my lord,
Digor is not the wife of Shubal.
I do not know, because my lord, that is,
Where is your statement that you have said that this Digor is not the widow of that Digor? Show us.
my lord,
Don't make extempore submissions, Mr.
my lord, a written representation when I have made,
Yes, page.
my lord, here it was not annexed part of, earlier.
Not annexed, you cannot rely.
My lord, I cannot improve my case without this.
So why didn't you annex it with your opposition?
My lord, that was in the night.
We have heard for 1 hour. Now you are saying that I want to rely on this, but you have not given it in your opposition.
My lord, may I submit? In the,
You may submit anything, but how can we place reliance upon that? Is that a part of the proceeding?
part of the proceeding.
Then why has it been annexed in the writ
In
petition?
the writ petition, they have not annexed.
You are sure?
Yes, madam. They have said the written representation to file, you file. I have filed written representation.
He has in your application, in your original application, you did not annex?
In the original application, it was not annexed. Written representation was not annexed.
Now, have you crave leave in your opposition that I will produce the written?
No, my lord.
Then
And your lordship, they were given chance for cross-examination, your lordship. They didn't.
yes, show us your reply.
Yes.
Mr. Sarkar, this is not the manner of conducting a case. This is not the manner. You are quite experienced.
I'm
Mr. Sarkar.
sorry.
Give a copy to her.
Yes.
These they have quoted. What you are relying has been quoted in the disciplinary authority order. Kindly come to page 74.
Yes.
It has been quoted in the disciplinary order. Which portion? Page 74, have you got it? Quoted portion. while disagreeing.
Lord, page 76.
Yes.
In page 76, paragraph 2.
Yes.
I would like to reiterate the fact that the charge sheet and its imputation should be so transparent so that adduced documents itself speak the imputation. The prosecution adduced some withdrawal
Mr.
form.
Sarkar, you tell us who were examined.
Who?
Who were examined? Kindly come to page 54.
Yes.
Harurani, Somir Rai, Anando Konar, Madan Mohan, and Sanjay Mondol were the witnesses.
Witnesses. And some of them have not come.
Who are they?
My lord, Sanjay Mondol, the informer in the FIR, he has not come.
Sanjay Mondol has not
Not
deposed.
come.
He was
the inspector of post.
inspector of post, means postal department employee.
Postal department, he is the authorized person.
Authorized person of what?
My lord, in my work, he has to look after this entire thing.
And others deposed.
Other deposed. And my lord, so far Somir Rai is concerned, in criminal case, he did not come. In the DA proceedings, he come.
Somir Rai is the SPM.
SPM, Gelia. He appeared in the DA proceedings, but not. No, DA proceedings he did not appear. And my lord,
Somir
Madan
did
Mohan,
not appear in this proceeding. Departmental proceeding, he has
he
not deposed.
has not appeared. And my lord, Madan Mohan
Are you
Jana,
sure, Mr. Sarkar, or you are listening to what your client say? Have you checked up, Mr. Sarkar?
my lord, in the order itself, they have not written. And Madan Mohan Jana, in criminal case, he was absent. In the DA proceedings, he present.
Where is Harurani's statements?
Harurani,
Harurani deposed. Where is Harurani's statement?
কত পাতা? ওই এটা DBG এটা কোটা এটা
Who was SW5? Page 77. Who was SW5? দেখে আসবে না, আমাদেরই দেখতে হবে এর থেকে বের করে। SW4 এর ডিপোজিশনটা আছে, SW5 এর ডিপোজিশন আছে, বাট হু আর পেজ 77 এ দেখেছো?
পোস্ট 5 কোথায়?
ডিসিপ্লিনারি অথরিটি 75 থেকে 6 এ থাকে, 76 এ। সেভেনটা কোথায় পেলে? সেভেন page 76 SW
document is
পরের পাতাটায় আসো।
Statement whether SBI can be
Depositor marked as SW4 depost. Depositor মানে কোন
SW5 টা কি?
জমা দিয়েছে।
State of this case. না সিএ অ্যাকাউন্ট
হচ্ছে SW5 এটা হচ্ছে SW5 টা হচ্ছে আমরা হচ্ছে এস উইটনেস, উইটনেস এস মানে কি বলতে চাইছি, এম ডব্লিউ
Yes, what are you arguing? Tell us.
My lord, in the written representation in page 46, 46 in the written representation,
Yes,
it is of page internal page 3.
yes.
Here I would like to reiterate the fact, paragraph 2, that the charge sheet and its imputation should be so transparent so that adduced documents itself speak the imputation. The prosecution adduced some withdrawal form SB7 for corroboration of imputation like a grave misconduct or misappropriation of government money. As per existing procedure, a withdrawal of money would not be done without production of passbook. The official who is authorized to pay money should make a entry in the submitted passbook before payment of money. SB7 is nothing but a voucher which shows that the money has been paid. The prosecution did not disclose such valuable documents and to show whether any entry of money is there in the alleged withdrawal from which passbook it was taken place before preparing the chart. The prosecution has no right to conceal such valuable documents for imputing me. Most astonishing fact is that how the inquiry officer came to the above conclusion while he is an independent judge of quasi-judicial proceeding. Second para. Again, the inquiry officer avoided cleverly my argument of my above observation. In earlier para, I have been discussed that SB7 is nothing but a voucher to support of a transaction. I have received the passbook from the depositor along with the very SB7 and charged under due entry in the office records and paid the amount to the payee. Had the prosecution would consulted it with the passbook, it would have clear that the amount actually paid to the depositor who placed it for withdrawal of its money. The voucher is not sufficient for establishment of such grave misconduct. Moreover, there was no complaint from depositor even after long time of the alleged transaction for reasons which is now discussed above.
Why he will complain? You returned the money. Why he will complain? You took it away, you returned the money.
Money was returned.
Money was returned once the put of duty order was passed.
They have threatened me if I did not deposit, the service will be terminated. Ultimately, it has been terminated.
No, you are saying that there was no complaint from the depositor.
Depositor, there was no complaint.
So your charge sheet was dated
53.
25th of April 2012 was the put of duty.
Yes.
Now where is this inspection report? This
Inspection.
kindly come to the judgment impugned second page.
Yes.
Applicant Srimanto, what you have to tell us why the proceeding must have been initiated on the basis of any complaint.
On the basis of a complaint by Mondol. He is the inspector.
That is, kindly come to the second page, third page of the order impugned. The applicant, got it?
Page, my lord.
Internal page 3.
150.
Okay.
150.
Paragraph 3.
Yes. Yes, my lord.
Read it.
The admitted facts called out from the reply filed by the respondents would be as under. The applicant Srimanto Kumar De, while working as GDS BPM Bongshi Chandrapur branch office in account with Geliasa office under Bishnupur subdivision of Bakura district, a surprise visit was conducted by Inspector of Post Bishnupur subdivision. My lord, here also there was no complaint. It's a surprise visit to inquire into complaint lodged by villager against Sri Srimanto De. My lord, that is also not clear. Who has made complaint? Sri De committed fraud by making such.
Upon verification of the records, the following position was given. Was there any verification report?
Verification report.
Must have been a preliminary inquiry.
Preliminary inquiry report was not submitted to me. Neither I have given any chance for preliminary inquiry report to be handed over to me.
So where have you taken that ground?
My lord, in the original application I have not taken.
You say you don't know. Page 60, kindly come. Kindly come to page 60 of the lead petition. Appearing or
yes.
A date of preliminary inquiry held on 8th October 2014. Oh, this is not a preliminary. There is a part of this because charge sheet
Preliminary hearing.
on this day absented. Charge sheet হচ্ছে 13 না
Preliminary inquiry report was not handed over.
No. Where is your original application?
Yes, in the original application they have annexed. Annexed with page 20, page 25 in the read petition.
Yes, anything else?
No, nothing. My lord, so far the written notes of argument, I have given 3 judgments. One is for the tribunal, my lord, bank upon the BC Chaturvedi's case. Your lordship knows the heavy punishment has been given. And my lord, so far the punishment, as they have told, it is a major penalty punishment, your lordship knows. In the DA proceedings, in the my lord, major penalty charge sheet, the 3 punishments are there.
Where you are?
Removal, dismissal, compulsory retirement in the central government CCA rule. And my lord,
What are those? Compulsory retirement?
3 punishment. Number 1, compulsory retirement, number 2, removal, number 3, dismissal.
They have proceeded on the basis of engagement rules.
Engagement rules supported by DA proceedings.
Maybe, but what can be the lesser punishment than that?
Their punishment is two, whether in their case, punishment is dismissal and removal.
No.
Those are major punishment. Other than major
Are you
punishment,
meaning to say that the engagement rule will not apply?
engagement rule apply, but
To show us, read what is the rule 9 of the engagement rules. What is the punishment? Please give him the rule.
censor, debarring a sevak from appearing recruitment examination for the post of multitasking assistant, debarring of a sevak from being considered for recruitment of multitasking group C on the basis of selection cum seniority, recovery from time-related continuity allowance, and removal from engagement, which shall be disqualification for future employment. So they are saying,
They are saying that we have not given the most severe punishment.
so that is the severe punishment. Otherwise, dismissal from engagement. So only dismissal from engagement, which shall ordinarily be disqualification for future employment.
That is not the punishment imposed.
And my lord,
Punishment-
he is at the age of 35. He cannot get any other service.
So what, according to you, did the tribunal say? What lesser punishment?
Tribunal says other than removal, dismissal, any other punishment.
On what basis? What was the finding of the tribunal? Show us.
Tribunal said, my lord,
On what basis tribunal said that reduce the punishment?
my lord, I am showing. My lord. Yes, my lord. Right from page 4, my lord, page 152. It has been written.
Page 152.
Yes, my lord.
Which paragraph you are reading?
My lord, I am page page 3, paragraph 3, my lord.
Paragraph 3 is the facts of the case stated.
Yes.
We want the finding. Come to
Findings.
paragraph 10.
Legal lacuna, para 4, page 154. The purported put off duty, charge sheet, inquiry report, and punishment order authority, that revising authority are bad in law.
These are your grounds.
Yes,
which you took.
grounds. And my lord, the courts finds that Roop Singh Negi's judgment and B.C. Chaturvedi's judgment. And my lord, last paragraph 6. While visit at Bongshi Chandrapur branch office on 25/4/2012 by the Inspector Post Vishnupur subdivision for inquiry of a complaint lodged by villager named Harurani Digor, wife of late Subol Digor. My lord, this is contradictory.
Why?
My lord, the Harurani in the impugned charge sheet, before making charge sheet, it was said that one inquiry officer, that inspector, while visiting the office, he has found some irregularity is there. But here it is written,
Where is that written? Inquiry report, where is it?
where is in the inquiry report, it was not given. It was not said.
Statement that somebody conducted a preliminary, somebody conducted
A preliminary
inspection.
investigation. Yes,
This 25th of April 2012.
yes.
Where do we find it? Where is the reference of that in the charge sheet?
In the charge sheet, there is no reference. And my lord, here interesting point is, while visit at, my lord, I am reading one line. The subdivision inquiry of a complaint lodged by villager named Harurani Digor, wife of late Subol Digor, Bangshi Chandipur, it was revealed that 2,197 was withdrawn on 28/3/2011 on closure proceeded premature from RD account 86613 standing at Bangshi Chandipur branch office with the name of Subol Digor, who expired 5 years ago. In addition, 81 letters were found undelivered at the branch office, out of which 16 letters were under delivery jurisdiction of Bangshi Chandipur post office, and another 65 letters were under delivery jurisdiction of Madan Mohanpur branch office. Instantly, the BPM was placed under put of duty as PWV was started. On through PWV, it revealed that they committed fraud to the tune of 9497. The respondents have categorically stated that a charge sheet was issued on 26/11/2013. The applicant had submitted his written representation 9/12/2013, where he strenuously denied the charges. The preliminary hearing of Board of Inquiry started from 8/10/2014 and was concluded on 6/4/2018. The punishment imposed by order 27/9/2018, whereafter the applicant preferred appeal and revisional application. Revisional authority has specially mentioned the following observation.
Inquiry into the complaint lodged by but upon verification of record, where is this?
চার্জশিটে হচ্ছে ও 124, 133, 134 ভায়োলেট হয়েছে। তারপরে আসছে continuity and execution. What is BO rules?
Branch office rules.
Branch office. Allegation is that he has violated 124, 133 and 134 of BO rules and thereby violated 21.
And my lord, it was the intention of the learned judges to consider it in view of my lord BC Chaturvedi judgment.
Consider
Because
the punishment.
Punishment,
Only
page
the punishment.
162, it was, my lord, written, going by the decision of Honorable Apex Court in BC Chaturvedi versus Union of India, it is seen that if the punishment imposed by disciplinary authority or appellate authority shocks the conscience of the court, it may appropriately mold the relief instead of directing the disciplinary or appellate authority to reconsider the penalty imposed. To shorten the litigation, it may itself in exceptional and rare cases impose appropriate punishment with cogent reasons in support thereof. The reason why the gravest penalty had to be inflicted on the applicant for a petty sum of rupees 9,000 and odds, which robs him all interned benefits is not comprehensible. Accordingly, the revisional authority's order is quashed and the remitted back to the authority to consider the order of acquittal and evidence in support of the conclusion against the applicant and on the basis of extanting factors. My lord, here they have come with the facts, they have made the inquiry properly, and for that the punishment was right. My lord, here the tribunal said the punishment was inappropriate.
Where is this, madam? Where is page 54? If you kindly come to page 54. Annexure 4. Homir Rai and Sanjoy Mondol did not depose.
Your Lordship, witnesses. Your Lordship, this too, I'm not very sure, but from the order, I don't find anything like that.
Now,
They have
page
deposed.
54.
But they had given a written statement which was.
Where is that Homir Rai written statement?
Your
Page
Lord-
54 refers. Page
Yes, your
54
it
refers.
refers, Your Lordship, but all the depositions, all the things are not annexed here,
That
Your
is a
Lordship,
written
because
statement, not a deposition. There
it's
must
a
be
written
some
statement.
reference to that.
That's what I said, Your Lordship. It's a written statement, Your Lordship.
Where is that? Can you show us that written
Your
statement?
Lordship, it's not annexed, Your Lordship,
No, no.
because
Has it been referred to in your inquiry report?
Costa, yeah, cost চিপটা
ক্রস করতে পারিনি কোথায় দেখবো?
appeal করে কেন? Appeal করে।
আমার মনে appeal করেছে।
এখানে করে কেন? Criminal appeal করেছে।
বডি কমপ্লেন।
হ্যাঁ। Madan Mohan Jena appeared before the inquiry officer.
In the DA proceedings, he appeared. In the criminal case, he did not appear.
In criminal case he appeared.
Because he has, my lord, he suppressed something before the criminal court.
Case
Criminal case, my lord,
was 235, that means after taking evidence.
Your Lordship, he had appeared also in the departmental proceedings. Your Lordship will find from page 64 bottom, Your Lordship.
Come to page 63, Madan Mohan deposed at PW3 before the criminal court.
Yes, Your Lordship. He had even
এইখানে ওই যে সত্যি সত্যি কথা আমরা
এবার তুমি ৭৭-এ আসো।
Your Lordship, page 64 bottom, Your Lordship will find that he had deposed, Your Lordship. The depositor of the last paragraph of the above SBPB clearly stated in the board as I, Sri Madan Mohan Jena.
There is no dispute that Madan Mohan has deposed. We are asking
Your
about
Lordship,
the other persons.
Your Lordship had asked about the whether he had deposed.
Madan Mohan deposed.
Yes, Your Lordship. Yes, Your Lordship. Page 64 bottom.
legal value. সেটা তো
Your Lordship, page 65, Your Lordship, paragraph 10. Arguments of PO. Stated, Your Lordship, one.
Yes.
11th line from the top.
65.
Page 65,
yes.
Paragraph 10. From the above, paragraph 10 from the above, I think it's the 10th line.
In page 64, it is written that Madan Mohan Jana's deposition is of no value.
Your Lordship, it was confirmed by Srimati Harurani Digger that her husband late Shubal Digger was illiterate person. Sri Sanjay Mondol.
You didn't annex the minutes of inquiry proceedings, nothing. We could have find it.
Page 77 पे আসো। Deposed as in the question 1. State whether SB account acquisition is তার আগের line requested to go through the deposition of witness marked as SW5. কে SW5 তাই আমরা জানি।
Sanjay Mondol had deposed it.
SW5.
SW5 is Sanjay Mondol.
Your Lordship, Sanjay.
So Madan Mohan Jana.
Confirmed that Srimati
Madan Mohan Jana.
Madan Mohan Jana.
Sri Sanjay Mondol, son of late Shishir Kumar Mondol, the then IP Bishnupur subdivision under Bakura division, who was produced before the Board of Inquiry as state witness, was marked as SW1. Your Lordship, 65, paragraph 10, Your Lordship, 10th or 11th line, Your Lordship. It starts from, it's after it was confirmed by Srimati Harurani Digger.
You are not being able to show us the verification report, which was the initiation of the proceeding.
The preliminary inquiry report, Your Lordship.
The judgment refers to 25th April 2012. The inspector conducted an inquiry.
On the basis of which the put of duty was passed, Your Lordship.
Yes.
Your Lordship, it's not annexed, Your Lordship. Don't think it's annexed.
If it is not
Amader-
annexed,
Amader-
then the very basis of your charge sheet goes. Your
Your Lordship,
story
that's a
is-
preliminary inquiry, Your Lordship,
it's an
on the basis of
inspection.
which inquiry was started.
Right. But that fact is not referred to in your charge sheet. In the charge sheet, subject to correction, we do not find any reference to 25th April 2012. Because that was the inspection conducted, records were verified. Anything else?
No.
So your only submission that the punishment is proportional.
Disproportionate.
Shockingly disproportionate.
That is the court's, trial court's view also.
He has a family.
Yes, sir.
Huh?
He has a family, son, and wife, father, mother.
What he is doing now?
He's not doing anything.
He's not doing anything. So how he is surviving?
In the village, your lordship knows so many persons are like without work.
So have you ascertained that, Mr. Sarkar, that
You don't-
how he had survived from 2012 till 2023?
Your Lordship, even in the
But
village,
villagers
Your
will
Lordship,
tender money, he will credit it within himself and now he will shed tears.
Yes,
It's a fact that he has returned 9,000.
it is.
It is a fact. Now the tribunal has shown mercy upon him. Now it remains to be seen whether we apply our
And your lordship, he's saying about
proportionate.
his client, but what about the villagers?
Your argument can at best be that my refunding the amount does not wash away the stigma which has been imposed.
Yes. It is correct.
সেটা একটা চার্জে
মনে হলো একটা বিছানা করছে এরপর বললে সময় চলো আমার শুধু একটু করে করতে চুরি করলে কি হবে এ করলে কি
সেখানে ডিসকাশন বিছানা
চলে টেন করাটা উচিত হবে কি হচ্ছে সেই একটা এবং তার একটা
সেটাই তো ডিরেকশন squashed, remitted back to consider order of magnitude and evidence in support for on the basis of the external if any. বুঝতে পারছো consider
একটা ডেথ সেন্টেন্স
না না এটা
ডেথ সেন্টেন্স এটা হচ্ছে লাইফ
এটা না অর্ডারটা
Side, even this honorable court has upheld that order.
which one
The put of duty order, your lordship, that is the first order.
that has
25/4/20.
that has ultimately merged with the order of dismissal. There is no put off now. He has been dismissed now.
Yes, your lordship. But he had tried to challenge it in various forums, your lordship, but it was upheld.
The learned advocates appearing for the respective parties have concluded their arguments. Judgment is Yes, next.
Right. Number 21, 22, 23, your lordship has been pleased to direct me to inform the other side to take up the leave to appeal matters. My lord. We had informed the other sides also.
All the parties are here.
Yes, my lord.
I'm in 21, my lord.
Our matter is in the monthly list.
22, 23.
I am in 21.
Who is for the state?
Please come. Mr. Pontu Devrai, my lord.
Huh?
Mr. Pontu Devrai.
Call him. We cannot take out of turn unless all are here, na?
Yes, my lord. But we had informed that Mr. Rai was here only.
See if he is there.
Our matter in the monthly list at page item number 46.
246.
246.
Who is for the state in that?
Mr. Pontu Devla.
All.
We cannot take it up out of turn unless all are here, na?
That's true, your lordship. Well, let's do one thing, keep it tomorrow in the morning.
Tomorrow it will be there.
Tomorrow, my lord, I'll not be there.
Day after tomorrow, any
শুক্রবার দিন শুক্রবার দিন আজকেই চলে যাচ্ছে
Then let it remain in the list. Let us see how.
All right.
Yes. Next. 16. You.
246. Monthly list.
Yes.
Item 15, your lordship, I am for the petitioner.
Who is your other side?
Your lordship, may I file the affidavit of service?
Oh, it's a new matter.
Yes, your lordship.
Mr. Ranjan Kumar Sinha and Smita Das, they are applying for Union of India.
Compassionate appointment.
Yes, your lordship, of a physically disabled person.
No scope for any interim order.
Your lordship, no scope at the moment, my lord.
We fix up the appeal.
Yes, your lordship.
Then all pleadings.
I
are on
appear for the
record.
respondent.
All pleadings are on record.
Your lordship, all pleadings are on record. May I humbly just beseech your lordship in the event the order may not be given effect to. That is all, your lordship.
What is the order?
The order, your lordship, dismissal of my application wherein I sought compassionate appointment pursuant to my father's death, my lord. I'm a physically disabled person. I had made representations. It has been dismissed on the ground that compassionate appointment is not a matter of right, and my representation was considered 2-3 times, your lordship. Thereafter, due to the marks or due to the result, your lordship, it was not given to me.
Oh, under the scheme, there was a marking.
Your lordship, there was also a policy wherein 3 to 4 times the representation could be considered. So the learned member, your lordship, considered that policy, and on the basis of which he's decided that since it has already been decided 3-4 times considered and the petitioner could not make it, therefore there is no infirmity in the decision, my lord.
So where is the scope for interim order?
My lord, not really, but
There's no scope for interim order.
Even Lordship kindly sees the last page, my lord. The policy of the
Now,
Lordship, what has happened is the contentions of the respondent had been verbatim taken to be true and correct, and as a matter of which the order has been passed on the basis of that. According to me, my lord, there has been no basis on which
the fact that it was rejected 4 times earlier.
yes.
that has been,
Then-
that I have to take instructions, my lord, whether I have been notified, because I'm in receipt of only one.
To have been your ground in the present writ petition,
Your-
you have not taken that ground. Subject to correction. We are just going through the pages.
Yes, your lordship, I have only received one letter, my lord, that is 8
Was
June
it received
2010.
4 times?
Yes, my lord. Lordship kindly come to last page, my lord.
Yes, last page, what?
Third paragraph, my lord. Basis of the respondent's policy on the subject stipulates as under the maximum time a person's name can be kept under consideration for offering compassionate appointment will be 3 years, subject to the condition that the prescribed committee has reviewed and certified the penurious condition of the applicant at the end of the first and the second year. After 3 years, if compassionate appointment is not possible to be offered to the applicant, his case will be finally closed and will not be considered again. The applicant's case was admittedly considered 4 times, and having failed to secure appointment for the applicant, his case has been rightly dropped.
My lord, I just received instructions from my advocate on record to not press for the interim order at the moment, my lord. May it be kept for hearing.
No scope for entry order. Why is this?
No, there is no scope for interim order and it appears for final
My lord,
order.
My lord, the only difficulty is that the person is in a precarious situation for a very long time. Right now, he's practically living as a hawker. In the facts and circumstances of his case, your lordship, I beseech your lordships to kindly consider.
Earlier occasion, it was rejected. What was the ground for rejection? Do you hold any allotment of marks for certain components? Where is
But I
the
cannot say,
scheme?
it is apparent from the order, my lord.
You are not on, your scheme says that after 3 years, it will not be done. Now, the person medically decategorized or something in 2007, we are in 23. What are the grounds of earlier rejection? Have you brought that on record?
That I'll have to take instruction, my lord.
You know,
Because in this
has it been referred to in the order that earlier
probably
thrice it was rejected on such and such?
probably, my lord. Let's check up. Paragraph 3, my lord.
Paragraph 3 we have seen.
Applicant cases considered
We
4
want
times
to know
between.
the reason for earlier rejection.
Oh, reasons for earlier rejection was, my
It was
lord.
rejected twice earlier, 4 times earlier.
4 times earlier, rejection was on the ground. Just 1 second, my lord. Paragraph 5, my lord.
Now kindly, but his merit
Paragraph
marks
5,
fell
my
short of cutoff.
This policy, paragraph 5, my lord, just 3-4 lines after. This policy has been framed in accordance with the DOPT
Kindly come to the preceding page.
preceding page.
Yes, kindly come to the last 3 lines. Applicant's case was considered 4 times.
4
Got
times
it?
between two.
Yes. But each time his merit marks fell
fell
short.
short.
We want to know that you gave the merit marks on what basis?
Oh, that is also stated, my lord. Just 1 second.
If you can show us
Yes, my
that
lord.
he
Yes, my lord. Paragraph 5, my lord. Paragraph 5. It is stated.
Paragraph 5 says that we have considered 3 times, we are barred from considering any further. Finished. That is your scheme.
No, even the marks has been set out.
Paragraph 5.
Yes, my lord. In September, last paragraph 5 at the bottom. Is in September 2008, he was placed at serial number 52 against 12 vacancies. In December 2008, 2010, 2011, number of vacancies available for compassionate ground appointment was 12, 17, and 13, and his rank in the merit list was 70, 79, and 49, respectively.
Since appointments are made strictly based on the candidate's rank in the merit list, the applicant was not recommended for appointment in any of the years mentioned above.
There is no case, madam.
Your Lordship, I understand from the beginning, Your Lordship, I said that this is practically a mercy petition before Your Lordships. Considering his facts and circumstances, if Your Lordship kindly.
On the 3 occasions, he was tested on the basis of the marks which he had obtained.
Yes, Your Lordship.
And that earlier rejection was not challenged by you also. It is
Your
only
Lordship.
after thrice rejection you came.
Your Lordship, then we went up to, then we filed the application, my lord. And then after that, Your Lordship, and we had given representations, and the only letter we were in receipt of is the 8 June 2010 at page 25.
This fact is not disputed, na, that it was rejected on the basis of the marks which were obtained and the merit position. So what remains? তুমি বাঁচাতে চাইলে আর my brother is in your favor. What can be done?
And now you are seeking benefit on the ground that you are a physically handicapped person.
Yes.
Is there any allotted marks for the same?
Your Lordship, what has happened is in the reservation under section 34 of the Physical Disabilities Act, Your Lordship, there is a right of reservation, my lord.
Ma'am,
But
that
what
is
happens
not
in
your ground.
compassionate, yes, Your Lordship.
It's not your, what my brother is saying, that had you been a physically handicapped person, then in the scheme, there must have been some sort of leverage for that sort of a person. So the ranking itself becomes defective. If you are entitled to any special privileges under the Disability Act.
And in
that
the
ought to have been your ground.
practical sense of it, Your Lordship, when competing as a physically disabled person also, it becomes difficult.
Where is your pleading? Where is your original application? You have said,
Yes, yes.
said nothing.
The application is at page 29, Your Lordship.
No, that is your yes. 29.
That is my application.
What opposition they used? Where is the opposition?
Their opposition, Your Lordship.
Their reply to your original application? That also
Lordship,
you have
reply is not annexed.
Did you give any, after they filed reply, you gave rejoinder? Was the matter decided upon reply rejoinder?
May I seek instructions? One.
Reply rejoinder was
I
there.
was not there at that point of time.
So did you file any reply?
I have to take instruction. I was not there at that point of time.
Your Lordships, we also have to seek instructions with regards to that.
They have not annexed in reply also.
আচ্ছা reply rejoinder use করে না বাড়ি আছে কিনা এই আছে কিনা ওটাই supplementary file a supplementary affidavit annexing those.
Grateful, Your Lordship.
The learned advocate appearing for the petitioner prays for leave to file a supplementary affidavit. Let such prayer is considered and allowed. Let such supplementary affidavit be filed within a week.
Yes, Your Lordship.
within a week with copy to the learned advocate appearing for the respondents. So please the matter for further consideration in the daily supplement list of this court on 1st December. Yes,
Grateful, Your Lordships.
উপরে video service file by the petition of your
But I for the petition.
You're for the petitioner.
I for the petition.
Well, it's a new matter. It's a new matter.
New matter.
What is it? Union of India.
Union of India. Railway Authority, so Union of India petitioner before Lordship. Yeah, my lord, we are challenging the judgment and order delivered by Central Administrative Tribunal on 23rd June 2023, whereby the Learned Tribunal, 13 June 2023, whereby the Learned Tribunal is pleased to direct the railway authorities to offer the appointment in the post of substitutes. So for the respondent is concerned, who are the applicant before the Central Administrative Tribunal. But we are agreed with this order because this order has been passed, but the way has been filed pursuant to the directions given by this honorable bench, honorable court, another coordinate bench, that could remand it back to tribunal further for reconsiderations, taking into consideration other documents, etc., which was left over. And after considering these things, for the tribunal has without my submission on the ground, why I have filed the petition without applications of its own mind, pass this, deliver these judgments and order. And rather, I want to say by influenced by the observation made by the honorable division bench. Not independently these judgments had been delivered. But at first, kindly place me the judgment, or this is not the first OA applications filed by, taken out by the applicant or respondent. This is 4th round of litigations.
No, what is your challenge?
Challenge here, my lord.
You said that we have no problem with the order.
No.
You have saved from imposition of cost.
Save from only with regard to imposition of cost. But the operative or the mandate, what has been given, that we had been directed to give an offer of appointment to this respondent, who was the applicant before the Central Administrative Tribunal. So in the post of substitutes, now the twofold grounds, my challenge is, one, this post of substitutes has been abolished. Firstly, it's a policy decisions of the central government or the railway board. Second point, my lord is reading, I think so. একটা কপি কই একটা আমাদের কপি পড়তে হবে তো ওইটা খুলে দাও বাক্যটা পড়ে যাচ্ছে
Just give us 2 minutes.
Very good.
প্রথম থেকে অর্ডার গুলো কি কি হয়েছে ফিজিক্যাল অর্ডারে দেখাতে হবে করবে। আগের আগের ওয়েট
Yes.
Now, my lord, brief facts of the case before coming into the main issue, my lord. My lord, in 2005, my lord, railway authorities had made and published an advertisement seeking application for the post of this substitutes. But substitutes means in case of any emergency or due to exigencies, which is required from the administrative side for running of train, for the passengers' facilities, convenience, etc. Immediate stops are required. At that material point of time, this scheme was open. That in railway authorities invited in 2005 this sort of application from the interested persons. Well, the father of this petitioner, father of the yes, made an application on behalf of his son, who is the respondent, your lordship. He made an application. But a list has been prepared and which was published by the railway authorities. Total 303 persons' name was figured in that list. But the petitioner name is Prosanno Das, Prosanno Kumar Das. But in the published
What
list,
was his serial in the panel?
121.
And you gave appointment up to
but total 104 candidates got appointment at that point of time out of 303 numbers. Not all, because there are various reasons. There is a defect in their biodata, defect occurred. Many things occur. There's academic qualifications not matching with and etc. So 104 candidates got appointment out of 303 name published. Well, the one name which had been figured serial number 121
which shows Prashanto Kumar Das. So Prashanto and Prasanna is not the same person. Accordingly, well, the person we didn't find out who is Prashanto. So his appointment was not given in favor of him. Now, these things happened in November 2005. Well, long after 6 years, 2012, he made a representation before us that correct my name. So long after, already in the meantime, this appointment proceedings over, they had been regular appointment proceedings had been initiated, etc. After this scheme has been abolished, so and so, and this honorable division division bench of this honorable court injuncted us in 2013. I have come with the judge order also that not to give any appointment so far this post is concerned, that is substitute post, not to give any appointment till a fair policy guidelines comes from the railway authority. But we are helpless. We had totally stopped in making appointment in this post. Now, my lord, thereafter regular.
The Supreme Court order.
Yes.
This point was not raised by you before the Supreme Court. Now
Supreme
you are bringing this new point.
No.
That I cannot give appointment in 2020.
We also brought this point before the tribunal.
Forget it. What did the Supreme Court
Supreme
say?
Court said,
Internet-
yes, I appreciate lordship. Kindly come to Supreme Court's order.
Yes.
I want to start from Supreme Court's order.
Yes.
Kindly come to page 78.
That is quoted in the order.
Quoted, I am placing the relevant portion for
Yes.
78. What Supreme Court said? Last paragraph of the order. Or later, let's very short order. Let me enter things. Place the entire order. Two submissions are made. As you lordship got it, page 78. Two submissions are made by the petitioner. First, submission is that the High Court has wrongly recorded that no application was submitted by the petitioner before the stipulated date. The learned counsel points out that immediately after the issuance of the notice dated 2nd November 2005 by the railway authorities, the petitioner had appeared, given his details and submitted his applications. Other submission is that the name was included in the panel, but it was wrongly typed as Prashanto Kumar Das instead of Prasanna Kumar Das. Whether, this is very relevant, whether the petitioner had made an application in time or not is the matter which would be within the knowledge of the railway authorities. Response number 2. In these circumstances, we permit the petitioner to make a representation before the railway authorities within 1 month from today, and if the aforesaid submissions was found to be factually correct, appropriate decisions thereon shall be taken by the authorities within 3 months from the date of filing of the representations. So accordingly, it was disposed of. SLP was disposed of. So therefore, scope of proceeding with or for consideration by the authority as it was very limited as per Supreme Court's order. Supreme Court said whether the petitioner had made an application in time or not. So in time means in 2005.
Other points goes.
We had taken care of all the points.
Sorry, we do not agree with such argument of yours.
But I'm coming, but kindly consider the reason order according to
Supreme
this.
Court order, the scope of consideration is very limited.
Yes, that is my
Whether
point.
the application was filed and whether
This application was made within the stipulated period.
whether the name which was included was wrongly done or not.
That has also been taken care of it by a reason order in compliance of the Supreme Court's order. But kindly come once.
Yes.
Reason order at page, my lord, page
91.
91. Yes. Paragraph 1, 2 is not relevant. It's a copy paste. Yes, last paragraph. First page, last paragraph. The 2 sentence. The papers available with the railways show that no application has been received from the petitioner in the subject case. Next, this is for your appreciation that engagement of
Now you take this down. In this reasoned order, you take this.
Yes. Now
It was not there previously. Now
previously,
you are only
why my responsible submission, my lord, since we had taken the point before the Supreme Court, that's why Supreme Court, my lord, categorically stated or the scope had been limited by the Supreme Court. What would be the consideration by the railway authorities? That's why that is
Your-
being
so
reflected from the SLP's
your
order.
consideration, after consideration, you find that he did not file any application.
Within the stipulated, long after 6 years, he has submitted, he has come
What
for.
was the stipulated time, sir?
Because,
What
my lord,
was the stipulated?
Stipulated, I tell you, there must
have
be some
stipulated-
reasonable time. Stipulated means reasonable time. An application has come today in 2005, and I have come with for seeking a rectification of my application in 2012. In the meantime, my lord, many waters have flown to the Ganges, as you lord. So this is the phase. So, my lord, so after 6 years, my lord, is it possible, my lord, to go back the previous situations by the railway authorities? Well, my lord, already appointment has been made in all the posts. This is not the fixed post, not the sanctioned post.
Paragraph 10 read, paragraph 9 of the tribunal's order,
Perfect.
Supreme Court order was quoted.
Yes, paragraph 9 and from paragraph 11, the
Order was set aside.
set aside.
Now then what happened?
Then paragraph 11,
Hmm.
my humble submissions, there is one thing more. Paragraph 11 says, in this view of the matter, that means that is an order passed by the railway authorities. My lord, kindly permit me to place paragraph 11.
We are going.
Yes. নাহলে সুপ্রিম কোর্টের লিগ বলে দিল।
Paragraph 11.
Paragraph 11, this is the observations and the final findings of the tribunal. Only when I place paragraph 12, internal place 12, that is 11.
So, Mr. Nondi, why was your order dismissed? Why was 26th of July 2018 was set aside?
Because the tribunal said, so since that is the finding, since the High Court, the division bench of this honorable court remanded back the matter to the tribunal, saying that you adjudicate afresh, and tribunal in a mechanical process, rather being influenced by the High Court's observations, without giving any reason at all, dismiss, rather allowed these applications, way applications. So there is no specific reason.
So what was the prior round of litigation? What did High Court say?
But High Court said twice rejected.
Where is that order?
Yes, come. Kindly consider. I'm coming. High Court twice dismissed the petitions at page 66. Another coordinate bench will pass this order. This is very relevant.
Against this order, he went to Supreme Court.
Against this order, went to Supreme Court. Yes, yes. Against this order. Paragraph 66, page 66. Second paragraph. The court had accepted the statement made by the then additional solicitor general, that persons who were enlisted in the panel of 303 candidates would be empaneled as substitutes. The petitioner having not been granted the appointment as a substitute employee approached the tribunal for employment. The tribunal has dismissed his application. The tribunal noted that the petitioner name has not in 303 enlisted candidates, and therefore his application was rejected. A notice was issued on 2nd November 2005 calling upon those who were enlisted in the panel of 303 persons to submit duplicate copies of documents, thereby, namely, so and so documents are required. Information was to be supplied by 10 November 2005. Admittedly, no application was submitted by the petitioner before the stipulated date. So that was the date.
That was the ground.
The first application which was submitted was in the year 2012 only, after 6 years. Whether the petitioner further annexed the biodata of the petitioner. The petitioner now seeks employment on the ground that his name was wrongly typed as Prashanto Kumar Das instead of Prasanna Kumar Das. It is not possible to accept the contents the contention advanced on behalf of the petitioner had every opportunity to call upon the respondent to correct his name in the list of 303 candidates, which he failed to do after the notice was published on 2nd November 2005. The petition was dismissed.
So against the Supreme Court.
Supreme Court framed certain things for limited scope, demanded to the authority with the opportunity to pass a reason order, taking care of whether it is on their record, on what date this application has been filed for seeking corrections.
Where is that application?
But
That application is at page 69.
page 69. No, application is that is at page 80. Representation made as per Supreme Court's order. Page 80.
No.
Sorry.
You said no such application has been filed.
Yes, only the application has been filed in 2012. Kindly come to page 64. 64. First time we have received this application. Page 64.
Page 64.
Yes. Sorry. I'm sorry.
The applicant's original application order.
Not so. I'm sorry, madam. I'm coming. 62, madam. Page 62. 62 to order to. এখানেই বলা আছে। Can you come to page 62? It has been recorded in.
Just one. Tribunal order.
It is not possible to accept the compensation. The petitioner has every opportunity to call upon the respondent to correct that. সেটা করে তাহলে নিশ্চয়ই অ্যাপ্লিকেশন করেছিল, তাহলে তো কারেকশন করার প্রশ্নটা আসে।
সেটা ট্রাইব্যুনাল চেক করে WPC তে page 64.
Which failed to do after the notice was published on
submitted before 65. First application was in. Good job, sir.
Page 62 minutes. This is the judgment and order passed by the tribunal in another way, dated 22nd April 2016. Paragraph 3. It has been recorded by the tribunal that he made an application for correction of his name on 15 March 2012, and on the same date he made a fresh application for considering his candidature for appointment in the category D in the railway department. So facts are undisputed.
No. When did you file the application for correction of your name?
My lordship, I am coming to that. This is a case where the respondent railway authorities have done the mental of being a compulsory litigant, harassing me all
Take the mic. We cannot hear you. Please take the mic. Mic.
My lordship, what transpired in this case, there was a notification by the railway authorities on 2nd November 2005, wherein they had out of 1166 candidates shortlisted 303 candidates for the thing.
Facts. Please
And
answer our query.
My lordship, I am coming to that. Originally, I submitted all the documents on 9th November 2005.
9th November
2005.
Where is that? Have you annexed that?
My lordship, it is in page 37.
Page 47.
37, my lordship.
Page 47.
37, my lordship.
37.
Yes, my lord. 37, my lord.
37. Very good. But where is the receipt?
No receipt, no proof.
My lord, at that point of time, all the things were being dealt with manually.
Mhm.
All the things were being dealt with manually. And my lord, you will appreciate that all the supporting documents have been attested by them either on 8th or 9th November.
Where do we find that? 30. Achha, then what happened? That application was not considered. That application was not considered.
My lord, what happened here in this case? Originally, they empaneled 303 candidates.
Why you are repeating? We
My
knew
lord,
that.
I'm coming to that because it has got some ramifications. But the subsequently, for the rest of the candidates, they moved to the Honorable High Court, and it is only on 29th January 2011, the High Court gave a specific direction to give appointment to all the empaneled candidates.
29th of January.
2011. My lordship, what is being submitted is being submitted.
Page.
My lordship, that is there in the list of dates.
Were you a party in that? Were you a party in that writ petition?
No, my lordship.
So where is the order?
My lordship, the department itself has admitted that they had got an order from the Honorable High Court to give appointment to all the 303 empaneled candidates.
Where you are reading? Where you are reading? Where are you reading?
My lordship, it is the chronology of events.
My lord, he was not a party to these proceedings. Sorry.
Yes, court directed that you give appointment to the remaining persons.
My lordship, it is in para
Directed
2,
that
again it is in
consider-
para 2D of the petition also.
Kindly come to para C, same page,
Yes, my lordship.
last 3 lines. Court passed a direction to consider. Where is the direction that give appointment?
My lordship, para D, my lordship.
Para D, it was extending the benefit of the earlier order. What is the benefit? Consider. Where is that you have submitted that?
My
court
lordship,
directed?
all the 303 and panel candidates except myself for having my name spelled have been deprived of the opportunity of appointment.
That is a separate aspect altogether. What are you submitting? Why you are submitting wrong facts? You just now said that the remaining candidates approach and High Court said give appointment. Where is that order?
My lordship, that is there in the departments, their own petition, my lordship.
Well, one more thing.
We are already having problem. We will come back to it.
Very well. Now, just to assist your lordship, in 2013, another order has been passed
My
by
lordship,
injuncted
I would
us
like to
not to proceed. So far, this appointment is.
I would like to kindly draw your attention to the division bench order of this Honorable High Court on 18/2/2022.
Page?
Page 113, my lordship. There, the factual matrix has been dealt with by Honorable Justice Mr. Harish Tandon and Honorable Justice Mr. Saman.
প্রশান্ত তো ছিল
Yes.
My Lordship, again, I would like to draw your kind attention to the internal page 12 of the order that has been appealed against.
Yes.
And we,
We are asking you, why did the tribunal set aside the speaking order passed by them?
my Lordship, against
There
which,
was any paragraph on what reasoning the order was set aside?
my Lordship, this writ petition itself is not complete and comprehensive.
Why?
This writ petition itself is not complete and comprehensive, and there are so many missing data, and from here I am unable to present those things. Because at that point of time, tribunal gave a specific order to submit me the documentary evidence that I had filed the application. My Lord,
Speaking order. এই যে পেজ 114 এসে এবার previously না স্পিকিং অর্ডারে বললো যে রিপ্রেজেন্টেশন ও দেয়নি আর অ্যাপ্লিকেশন হ্যাজ বিন ডেপ্রিকেটেড এন্ড ডিসকন্টিনিউড এই ফাইন্ডিংটাকে সেটা
felt that since while passing of this speaking order, no holistic view was taken. That is the only reason, only one.
Another reason was there. Kindly come to the High Court's earlier order, page 130.
Yes, Justice Tandon, sir, presided over.
Kindly come to the 114.
Yes.
The court said that you passed you rejected the petitioner's case.
But the last 114, last part one paragraph, court said, curiously enough, by a speaking order, the railway not only took the stand that representation was not made within the time stipulated, but rejected the said application as engagement of substitutes have been deprecated and discontinued. Challenging the said speaking order, the petitioner approached the tribunal, but the tribunal, instead of going into the merit, proceeded to dismiss the application on the ground that no representation was filed by the petitioner in terms of the liberty granted by the Supreme Court. So here also, before your lordship, I am taking the same ground that Supreme Court's order or direction was very limited.
Show us the order. This is the WPCT order.
Lordship, tribunal's order. My lord is
the speaking order, which was challenged. The original application was filed.
Speaking order.
Speaking order.
Speaking order is at page, my lord.
Page, yes.
91.
26 July.
26 July.
No, that is the
only speaking order that is pursuant to Supreme Court's order.
No, page. Page 91 was challenged in which way?
Page 91, it has been challenged in way. Page বলুন।
This against which order of the tribunal this page 113 order was passed?
Page 113, on the basis of this honorable court, the division bench, Preserver Justice Tandon, set aside the speaking order and remanded back to tribunal.
That is page 91.
No, page 113. Justice Tandon's order, division bench order.
Set aside the order.
Set aside the order.
And remanded it back to you.
Remanded back to the tribunal to adjudicate afresh. Yes.
Oh, I see.
Reconsider.
So, Mr. Nondi, your first ground that this practice has been discontinued.
Lordship, my first ground is since Justice the division bench Preserver Justice Tandon by way of setting aside the speaking order, remanded back to the tribunal to reconsider by giving reasoning. Tribunal, rather being influenced the observation made by the division bench of this honorable court, but in a case of simpliciter, passed an order since we do not find any reason in not in this speaking order is not passed not in a holistic manner. I am setting it aside.
Right, because your by the order of Justice Tandon, your speaking order was set aside.
Lordship.
Why? Because you took two grounds.
Yes.
No application received and practice discontinued. So that order,
yes, two grounds.
Those two grounds goes because High Court says, Justice Tandon says, I find that he has made an application.
Absolutely correct, my lord. I appreciate lordship. For that reasons, tribunal upheld rather definitely it is binding upon the tribunal.
Mr. Nondi, this point that
I have again approaching with your lordship on the same ground that number one, the scheme does not exist.
That has cannot take Mr. Nondi because that has marched in the order of Justice Tandon's matter.
That was not considered because we can't also bypass, we can't suppress anything. In 2013, this honorable court injuncted the railway authorities. Kindly see the order. The not to give any appointment in substitute post.
You ought to have produced before Justice Tandon.
Not only Justice Tandon, before we also produced one that is also been recorded. By the tribunal also said so that we do not find this order of High Court that you had been injuncted by the Honorable High Court Division Bench that not to give any appointment in substitute post. But that is absolutely wrong. My humble submission.
You ought to have preferred review application against that order.
But since review,
consider.
That's why I have come directly before this honorable court, showing that the tribunal did not consider this order of this honorable court, and there is no scheme exist.
Tribunal considered.
No, not at all, my lord. Kindly see the order.
We are not bound by that.
No, order to tribunal order. কি শুনছো তুমি আর্গুমেন্ট?
That was taken into consideration.
We had taken this point that has also been recorded with the tribunal in the internal page 12.
Yes, yes.
But last but one paragraph, we have carefully gone through the office order passed by the then chairman, RRC dated 26 July 2018. That is a speaking order. The order, even though was passed in WPCT directing not to engage substitute till further order, Learned Counsel for the respondent states that this order is still pending adjudication before the Honorable High Court. But this order arising out of the WPCT is still pending before this Honorable Court.
Read the next
Yes,
paragraph.
next paragraph. Yes. We are not convinced by the arguments put forth by the Learned Counsel for the respondent in the peculiar facts and circumstances of the case. We cannot cross side that in present factual scenario of the case, the applicant was not at fault. It is a matter of record that the applicant has been pursuing his remedies against the notified vacancies of 2005. Therefore, the impugned speaking order should not come in way of the applicant in the present peculiar facts and circumstances of the case, more particularly in view of the fact that we are bound by the judgment of the Honorable High Court quoted herein above. So which judgment? The judgment quoted, that means the order passed by Justice Tandon's division bench. So that is also we are. And next paragraph also, let me conclude. However, the said order passed by the Honorable High Court has not been placed on record. So as if this order has not been placed before the tribunal.
What is that order? You
Order
were injuncted.
I beg your
Has it been decided that you have been injuncted?
Injuncted.
That does not mean that the posts have vanished.
No.
That you have discontinued the practice.
That is the policy of the, because policy guideline came in 2010.
দেখি ওই judgment দাও।
Policy guideline came in 2010. That no need of any exigencies for administrative reason. Now we are giving regular appointment. Only last but one operative portion. Last, Lordship.
You come to page 39. 39 and all.
Lordship.
It is the testimonials. It was attested by your official in 2005.
Lordship.
It is going on.
Lordship.
Now, even one of your official, page 46, give a certificate in favor of the petition. Here in favor of the, that means again respondent number 1. Prasanna Kumar Das. Got it?
Lordship.
In
I'm reading.
2005.
So far, I know. So this is
My lord,
mere
page
certificate.
45 also.
Come
That is
to
an
page 51. Come to page 51. Serial, again, serial number 21.
Not 21, 121.
Prasanna Kumar Das.
That is, these facts are, Lordship, on this.
Prasanna Kumar Das.
Yes.
Son of Kulamuni Das.
Kulamuni Das.
So son of Kulamuni Das.
Correct.
Applied.
Yes.
Now you took the point that he has never applied.
Applied when, my lord? That is the point.
2005.
In 2012. He made an application.
Your stand. I am saying your stand.
Lordship.
You have never applied.
Yes.
The tribunal used the word holistic.
Holistic. Yes.
Correctly applied. Correctly used the word. Now page 91.
tribunal.
time আছে, হবে না, কালকে করবো, একদিনে করুন। But time is, I think, so on a watch is warning us. I'll consider. Tomorrow may I come?
এইখানে দিয়েছে।
একটা পিজা হয় নাকি?
এই দুটো পিজা হয়। In response to the above mentioned submitted applicant was short for a correction.
Correction, হ্যাঁ।
2005-এই করে দিয়েছে।
5-এই করে।
এখন বলছে 2012 অব্দি করেছে।
Now in page 91, you took the plea
Yes.
that no application has been received from the petitioner in the subject case.
Lordship.
No application.
Application means what? May I interpret application for seeking corrections?
No, that was made.
That was made when?
Correction was made. So
That
show us that page.
My lordship, that was made on 9/11 itself.
9/11/2005, we didn't
Now, in
receive.
Page 99.
We didn't receive, my lord. That
by
is our.
filing Page 99, by filing a reply state, the petitioner had every opportunity to call upon the respondent to correct his name, which he failed to do so after the notice was published.
Yes,
It is your stand.
yes.
Change of stand. In Supreme Court, you said
He didn't make an application.
whether he filed application or not.
That was the scope.
In Supreme Court.
Yes.
You raised this.
Yes.
Supreme Court passed the order stating that you clarify whether he has passed the filed the
Filed an
application and whether there is a mistake in between Posanno and Posanto.
Yes.
If these are found, then you will pass appropriate.
My humble submission, my lord, Supreme Court
my
said
lord,
not
may I
only filed an application within due time.
Then Supreme Court gave liberty to the to Mr.
Petition.
Das to file the petition.
Yes.
My lord, initially,
Denied that he has filed the petition.
No, that is not me.
Yes.
That is, my lord, misinterpretation.
Yes,
No, my lord, we never said so.
you come to page 114.
114, that is my humble
114,
submission.
the-
That is, my lord, wrong interpretation.
One honorable division bench
Yes,
of the honorable
yes.
high court
I've gone through it. my lord.
even took trouble to check the seal.
May I-
Our attention is drawn to the representation dated such and such annexed as page representation. We could see the seal on the left side, bottom, at the first stage. And therefore, we do not find any justification either in the stand of the authority or the tribunal that the application was not made.
This is
by
not,
the
my lord,
petitioner.
no need to read further. May I explain? This recording of the honorable division bench of this court, my lord, not with regard to application as application
as per order of the
Supreme Court. That is not with regard to that. But it has been my humble submission wrongly recorded. My humble submission. This court wanted to explain or wanted to write it down, the application what he had made in 2012. Not this. We are never disputing. We are never disputing this application.
By a speaking order, the railway not only took the stand that representation was not made within the time stipulated, but rejected the said application as engagement of substitute have been deprecated and discontinued.
We are not with regard to, we are objecting to that. We are not denying that we have received his application pursuant to Supreme Court's order. But this has, however, the London Council who appeared erstwhile, it was the duty of the councils to brought it to the notice of the court. This is wrongly.
Was the place to ask you two things only,
Lordship,
not more than that.
Lordship.
Only two things, whether he made application or whether there is a mistake in place of Posanno, it was Posanto.
Kindly consider one more thing when he has made this application. That is my point.
my lord, I would like to draw your kind attention to
বলুন না।
আমরা ডিসকন্টিনিউ করি, হ্যাঁ বলে দিল।
And there is no substantive post vacant, my lord. There is no substantive post vacant. Where do I provide this person? Assuming we fail. Lordship.
Papers available with the relation, no application has been received by the petitioner in the subject. পাঁচ একটা ইয়েস কারণ সুপ্রিম কোর্টের অর্ডারটা অনেক পরে অর্ডারটা হচ্ছে আপনার 5/2018
এই কোশ্চেনটা আগে থেকে সলভ করে রেখেছি।
26 সাল
এটা বলা উচিত ছিল। সুপ্রিম কোর্টের অর্ডারের পরে যেটা অ্যাপ্লিকেশন রিপ্রেজেন্টেটিভ ওটা আমরা বলছি না, ওটা আমরা ডিনাই করছি না, এটা ডিনাই করছি। সুপ্রিম কোর্ট 2012 আমি জানতাম এই কোশ্চেনটা আসবে।
কারেকশনের জন্য
স্পিকিং অর্ডার
of the petitioner in the subject is would get a more popular would just is not holistic, is not approach is not proper. Or even Supreme Court the representation which was given in
My lord,
what is your
my lord, I kindly draw your attention to page 72.
72?
My lord.
Yes.
Initially, my lord, I was at the receiving end because I did not have any data to prove that what the department was doing. But subsequently, when I took the umbrage of RTI, and in RTI they have given one category reply that is in page 72 of the petition.
72,
my lordship.
what they have said? That no application of Mr. Das is available.
No application of Prasanta Das, the name which was misspelled. No application of Prasanta Das is available. Second, since there is no application named Prasanta Kumar Das, hence no appointment letter was issued. Prasanna Das did not file any application. Biodata and documents of Prasanna Das are found in the file and confirmed. Biodata and documents of Prasanna Kumar Das are found in file and confirmed.
No, we are asking you, page 37, your application for rectification and consideration, page 37.
My lordship.
Got it?
Yes, ma'am.
9th November.
Yes, ma'am.
Where what document you can show that this document was deposited, they accepted this document. Where from can you show, sir?
My lord, there is to be
documents of application.
My lordship, there is to be manual receipt and department has not given any acknowledgement. And since my father was a group D employee there, he has gone and submitted there.
The present writ petition has the present writ
But,
petition.
I have other also legal authorities to submit before lordship. But delay defeats the equity. Few judgments of Supreme Court.
Delay?
Defeats the equity.
What delay?
But delay, delay in making applications so that which defeats the equities.
We will deal with your argument.
But also, there is no right of appointment on this point. Now, kindly come tomorrow. Let me continue because I am to cite a few judgments. Otherwise, that will be incomplete from my end.
Acha, tomorrow we'll pass out.
Very grateful to you, Lordship. Because
এটাকে for orders বলে উপরে রেখে
kindly pass an order only. One line order. One line order may be passed. But only one line order may be passed for that day.
Acha, hardly learned advocates appearing for the respective parties establish the matter as per orders in the daily supplementary list of this court on কালকের date দিয়ে দাও। এটা
Grateful.
follow this.
Really good.
দুটোই কি মামলা আছে? That as fixed at 12.
12. Good.
Before the law,
Grateful.
I mentioned item 17, madam, and let it be taken on Friday, madam. My learned friend is appearing.
No, if 17.
Yes, next matter.
Why?
Learned ASG is appearing, he requested me to fix the matter on 17. For Friday.
We don't know where the position will be. If you are agreeing, then not Friday রেখে দাও। 17 টাকে Friday রেখে দিই।
Right, great.